All right. We're convening the where we are March meeting of the California Law Revision Commission. Can you follow the rules to establish quorum?
Yes, I will. Commissioner B.
Present.
Commissioner Carrillo.
Present.
Commissioner Kubas.
Present.
Senator Gomez Reyes.
Present.
Commissioner Huebner is not able to attend. I think Cara Jenkins will be joining shortly. Okay. Commissioner Jenkins.
Good morning.
I'm calling the roll.
Hi, I'm here. Thank you.
I do not see Assembly Member Pacheco. Okay. And then Commissioner King is not able to attend. And then Commissioner Simpson.
Here.
Okay, we have a quorum.
Quorum present. We will now suspend? No, we will.
We're going to move
We're going
to
to
closed session.
Move into closed session.
I don't have the email for the closed session link.
Okay, did you hear that, Christy?
We just sent it and do the others have it.
Does anybody else need a link to the closed session?
It's a meeting now.
Okay.
Oh, it's a new link.
I'm not sure that I have it. Am I going into executive session or is that you all?
You're welcome to join, but your presence isn't required.
Okay.
Still don't have it.
They're working on it.
Here, we'll pause the main one and then I'll send
Okay.
Okay.
Okay, we are back in regular session. And because of the time, we're gonna move to item number 4. Because the ASL translator is with us and that was scheduled to start at 10:45. So Steve, the recodification of toxic substances?
Yes, thank you. This is memorandum 2613. It presents another portion of this long proposed recodification that we've worked on for quite some time. A very lengthy and complex chapter of the Health and Safety Code. This chunk is presented for provisional approval by the Commission. If approved, it would be then included in the cumulative draft, which I've been presenting at both meetings. Ultimately, that cumulative draft will be the legislation that will go into a tentative recommendation from the Commission. And all these times, there will be opportunities for public comment as well. We typically don't get a lot of comment at this point in the proceeding, but maybe, the Department of Toxic Substances Control is reviewing what we're doing, and they have offered some comments. They're a little bit behind. Here's what we presented. But certainly once we get to a tentative recommendation, there would be an opportunity to get much more public comment on anything that we might have missed and needs to be tweaked or fixed. In this particular chunk, the only issue that I wanted to bring to your attention, as most of the things are, it's a pretty technical issue. It's discussed on page 3 of the cover memo. This particular segment of the chapter that we're recodifying has been in existence for some time. There was a special definition a long time ago, a definition of the word board was inserted in this particular chunk, which indicated that for purposes of this next chunk, the board means the State Board of Equalization. I believe that that's antiquated. When we looked at this, it looks that, I'm sorry, I'll back up then. I can hear. In 2021, there was much more legislation that affected this chapter and also enacted the Board of Environmental Safety, which is a board that works very closely with the Department of Toxic Substances Control and has a lot to do with these provisions. There are a couple references to the word board in this chunk of provisions that we're recodifying. Connected in the section with references to Board of Environmental Safety. And this has all been explained here in the memo, but it's our belief that the references to board now are intended to be references to the Board of Environmental Safety. That's also a definition in the Health and Safety Code of the term board for purposes of the entire chapter. So we put a staff note following the sections where there was this reference to the word board. And we've said we believe this is a reference to the Board of Environmental Safety based on context. But please let us know if for some reason that's wrong. I actually did a little further digging and it seems very clearly that the initial definition of the word board and referring to the Board of Equalization was because a long time ago they received payments which are referenced in these code sections. Now that's taken over by another department, the Tax and Fee Administration, and so it seems very clear, but we have an opportunity to hear from anybody who would know differently and let us know about that. So other than that, I'm certainly welcome any questions or comments. Otherwise, the request would be that the commission provisionally approve this presentation of recodified code sections for inclusion in a tentative recommendation.
Okay. Are there any comments or questions from commissioners?
I do.
Yes. Kara?
Yes, thank you.
Hi, Steve.
Hi.
So I just wanted to make a note that there's a group of sections that were, I think they're under Article 4, beginning, I have to admit, this is when I started kind of noticing it, starting at page 26 with section 84.355.
Hold on. Let me get to it.
So just for some background, it appears that there were a group of statutes that were enacted via a trailer bill. And so there was immediate effect, but the language of the statutes actually has a delayed operative date because the statutes didn't go really into operation until January, although the law went into effect in July. So there are a bunch of sections that say this section became operative on this date, but actually does not go into effect until this date. And so you have proposed to change the shall become effective or operative to became operative because obviously it's kind of in the past. But just so you know, our office style is to just remove that entire provision. If
The
it's
same as the whole subdivision?
Yeah.
So a section that indicated this section shall become operative, rather than referring to it, just take it out completely. In other
That's
words,
right.
once it's operative, then it goes away.
Right.
Okay.
That's how we would handle it in like a code maintenance bill. If we were amending the section. Now, of course, we don't go through every statute and take out those operatives provisions unless we're otherwise amending those sections.
What if there was a situation, I can't do this now, but with a particular section in which it was only discovered well after the fact that something had happened. And so it was important to know the date when the section became effective.
Yeah, so that information will still be in the actual bill that was enacted.
Right.
So if someone were to look on Westlaw, bring up the bill, it would still be in that bill language.
Right, but it wouldn't be in the code anymore then.
Correct.
The provision would no longer be in the code. Okay. I will revise that for purposes of the cumulative draft when I present it at the next meeting. And there might be a staff note to make sure that the commission is on board with that. But thank you.
Sure.
Very much appreciate that. And I will go through it and do all those things. Is there any indication at all that you would typically put in the published codes that would indicate that there was an operative date for something triggering, I don't know, what kind of sanction or something else that only took effect on a particular date? So that if it was only that the behavior was discovered, but it was prior to the operative date, it would be clear that there was no violation.
Well, even without a date, you would know when a statute, in the absence of that, you would know when a statute became operative. Because, it, is signed into law and then becomes, unless it's, an urgency statute, it becomes law in January 1 of the following.
Right, I guess what I'm saying is in the codes, at least, people have various types of codes in terms of the way they're put together. And there might not be an indication at the end of a section that says, this like indicates when this thing, it might even say when it was last amended or something like that. I mean, that's what's on much council's site, but it wouldn't say that prior to this date, the section actually was not in effect. And so if you engaged in behavior which is prohibited by this code section, but it was prior to that date, it's actually not a violation. I'm just.
So if I can just chime in a little bit, the annotations to the codes will show when they were amended and what the amendments were. So the legislative history would be apparent in the annotations to the codes, correct, Kara?
Yes, that's correct.
Okay. Anyway,
I will absolutely go through and make all those changes for purposes of the cumulative draft.
Okay.
Thank you.
Any other questions or comments from commissioners? Seeing none. Any questions or comments from the public? Any public comment? Seeing none. And we need a vote to move forward on this?
Yes, that would be appreciated.
And that would include the modification of the definition of board as you.
Yes, as indicated in the memo.
Okay.
Yes.
And the recommendation from Kara.
And Kara's recommendation. correct?
Yes.
Okay, is there a motion that we do all that?
So moved.
Been moved, is there a second?
Second.
It's been moved and seconded, call the roll.
Yes. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Senator Gomez Reyes. Senator,
Aye.
okay. Commissioner Jenkins,
Aye.
I still do not see Assemblymember Pacheco as present. And Commissioner Simpson.
Aye.
Okay.
Okay, thank you all, and thank you again to our translator.
Thank you very much.
All right. Okay, now we will return to,
Oh, we can discuss the
Yeah.
translator.
yes, and translator, you are free to go about other business.
And thank you.
Thank you so much, as always. Thank you. Okay, minutes of the January 30th meeting. Is there any comments or questions about the minutes? Seeing none, hearing none,
I move to adopt them.
then move to adopt. Is there a second?
Second.
Then moved and seconded.
Any public comment?
Any public comment? Seeing none. All right.
Okay, I can call the roll.
Yep.
Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Senator Gomez Reyes. You were not at the last meeting, so. I
That
assume
is
you're
correct, so
staying.
thank you.
Okay. Commissioner Jenkins
Aye.
and Commissioner Simpson.
Aye. Okay. Item 3, administrative matters.
Yes, so just a brief report on the administrative matters. We continue to monitor the budget situation. For now, everything is fine. So nothing really new on that. We are working with the Penal Code Revision Commission on a specific request. Office space. So some good news there. We believe we have identified a good fit for the office, which would actually be at 925 L Street, which is where Legislative Council is housed, the bulk of Legislative Council is housed. So we're really excited about that. It's already built out. So that should move the process up more quickly than if we had to do tenant improvements. So that's something that we've been actively pursuing. We've seen the space. We visited a few spaces. We really liked 925 L because of its close proximity to the Capitol. So we're really hoping that will work out. We continue to work on the website contract. I know Christy's been doing some further investigation into potential companies that can help us with that. It's sort of in terms of priority, we're focusing more right now on the office space. And we have some good news. We have hired a new attorney, and Amy Solari, am I saying her name right? And she will be joining the office on April 20th. So we're really looking forward to joining. She has came highly recommended. One of the things that I really appreciate is that she was the technical editor for her law review, which means that she's really good at footnotes and citations, and which is very important to the work that the commission does. So we're very excited about that. So that's all I have. Does anyone have any questions? Yes.
I have a question. Will we meet in the office space or somewhere else?
It would still be somewhere else. That we will have a conference room, and there's a possibility that we could do it, but it's really not big enough for to have public comment. So, but we will let everyone know when we're moved in, and perhaps we can have a commission visit to the new space after the meeting.
Great, okay, thank you. Any commissioner suggestions? Seeing none, hearing none. Want to kind of welcome Senator Reyes to the commission. You and I barely missed overlapping in the assembly. I retired from the assembly in October of 16. I guess you were elected in November of 16? Yes.
That is correct. And sworn in the end and started in January of 2017.
Okay. Let's see. Okay, legislative program.
Yes. We get to the right path. Okay, so we have a status supplement, a status update, and we also have a supplemental memo to discuss we've been working with Assemblymember Pacheco's office, who is also a commissioner, on the resolution of authority, which should be introduced soon. The staff is very grateful to the Assemblymember and her staff for their assistance. The state and local agency access to customer information from communications service providers. The commission had approved a final recommendation on that. We had ongoing discussions with the legislative member about carrying the legislation to implement the recommendation in 2026, but close to the bill introduction deadline, the member decided not to carry the recommendation this year. The staff was unable to secure another author for this recommendation by the bill introduction deadline, but we are looking into the possibility of amending the language into a pending bill from another member.
Okay.
The Equal Rights Amendment, again, the commission approved a final recommendation on that. And we're happy to inform the commission that Assemblymember Pacheco, also a commission member, has agreed to carry legislation implementing the recommendation in 2026. The recommendation has been introduced as AB 2563 and is currently pending referral to a policy committee. if you look at the bill, you can see the Office of Legislative Counsel has made some minor technical revisions to the recommendation language to conform to its drafting style. And I believe that bill is scheduled for hearing on April 7th. Yeah, so Judiciary Committee will be hearing it on April 7th.
Okay.
And so moving on to antitrust laws, single firm conduct. The commission approved a staff draft final recommendation on that single firm conduct. The staff is pleased to inform the commission that Assemblymember Aguilar Curry, who is also the majority leader, has agreed to carry the recommendation. The staff is grateful to the Assembly member and her staff for their assistance. Currently, in its current form, AB 1776 is a placeholder bill that will be amended to include the recommendation. After this memo was published, we did get draft language from the author's office. And so I just need to turn to the language, which is on my laptop.
This is the first supplement.
And that, yes, that is in the first supplement. So this supplement presents the commission's single firm conduct recommendation as drafted by the Office of Legislative Counsel for amendment into AB 1776. The staff notes that there are minor technical differences from the language approved by the commission, and those are outlined in the memorandum. I just want to say at the outset that this is not an invitation to reconsider any language the commission has already approved. A single firm conduct recommendation. This is merely to allow the commission to know what is in the draft as drafted by Legislative Counsel. And we're basically the commission or the staff is asking for approval to include the version that Legislative Counsel has drafted into the preprint version of the final recommendation, and that's the version that gets formally transmitted to the legislature. Our understanding is that in the past, that's been the practice of the commission to include the technical changes drafted by Legislative Counsel into a preprint version of the final recommendation. We do have some information in here about the practices of the commission with regard to Legislative Counsel drafts and other potential amendments that could happen in the future. The handbook clearly recognizes that changes may be made before introduction by Legislative Counsel, and that those may be made at the staff's discretion. Sarah and I have worked with the author's office and Legislative Counsel and closely looked at the language. We agree that the language that as drafted by Legislative Counsel is consistent with what the commission proposed, and they're merely technical changes to clarify a couple of things and to conform to Legislative Council's staff. As always, Kara's staff did an excellent job in fine-tuning the language from a technical standpoint. So that's pretty much, let me just scroll down a little bit more. So today, all we're asking for is approval by the commission to modify the staff final recommendation to conform to the Office of Legislative Counsel's language. We're not asking, but as I said, not asking for any further tweaks to the language. My understanding is in the past, the commission had or commission staff has not necessarily brought these kind of changes to the commission, but there was a lot of interest in making sure that the public was aware of what the changes are and that the commission was aware of what the changes are. So that's the reason we're bringing it to the commission. So
And so these are not changing public policy, it's.
No.
It's form and making technical corrections to.
correct,
Okay, got it.
correct. So the question, does the commission have any questions about the
The
language?
questions, yes, I think Senator Reyes had her hand up first.
First, I want to appreciate the author, Assemblymember Cecilia Aguiar Curry, who shared with me the purpose first of the legislation based on the recommendations of the commission, and also reviewing the technical changes that were being proposed here. So I do want to appreciate that. And at the appropriate time, I would move that we approve this.
Okay, and Commissioner Carrillo.
Yeah, regarding memo 12, the biennial resolution of authority, did the new study approval, new study authority request that we talked about regarding writs of mandamus, did that make it into the resolution?
It did. That is the language we sent to the author's office. I don't believe it's in print as of today, but we didn't get any questions or pushback on that at all. The study related to reporting requirements on local education agencies is also included.
Yeah, I saw that one. I just didn't see the one about mandate and mandamus. So I just wanted to make sure that it's in there.
Yes.
Someone's
Super.
gonna tell me what
Thank you.
mandamus means one of these days, okay. Any other questions or comments from commissioners? Seeing none, any questions or comments from the public? We have one.
Should I? Whatever's easier.
I don't see if there's a microphone there, so whatever you're.
You just.
Just talk.
Sweet. Just real short statement here. Want to first say thank you to the chair and the commissioners for taking on this process. My name is Loyal Terry. I'm here on behalf of Economic Security California Action, and in solidarity with many of the organizations you've heard from before and may hear from after me. I need to say thank you to the staff and to the commission for taking on a very long and strenuous process to make sure that our antitrust laws are up to date. Personally, this has been one of the most transparent processes that I've been a part of in the years that I've been working in the legislature in DC and now being back here in California. After these 3 years of extensive study with recommendations from academics, researchers, and practitioners, both from the public and private sector, we are excited and ready to move forward. From this strenuous review process, we have what we believe is a very well-balanced proposal in front of us today that will substantially strengthen our state's antitrust laws and enforcement. A few things were true when the study began and are still true today. Monopolies are real. Many are abusing their power in California today without consequence. This proposal was drafted meticulously as to not increase liability for mom and pop business owners, which we do appreciate. Frankly, it won't even impact most large businesses because most businesses aren't using their position to impede their competitors from also thriving in the market. The purpose of the proposal is to level the playing field and correct against the few businesses who choose to use their dominance to manipulate the market, raise costs for consumers, suppress workers' wages, and make it more difficult for small businesses to compete. We want fair and open markets. If that's not something that every capitalist can get behind, then we really do feel our values are misaligned and are appreciative of the work that you all have been doing to this point. If implemented, which we hope they are, these recommendations would close loopholes that have allowed monopolies to abuse their market power, making it clearly illegal for single corporations to stifle their competitors' ability to innovate, suppress wages again, and engage in other anti-competitive behaviors. The recommendations that you voted on before and are now voting to put in these technical amendments into the bill are well balanced and timely. Real people across the state need change now. These harms are not hypothetical. Californians cannot keep paying the price at the grocery store when they're buying healthcare or when their small business is being squeezed by mega billion-dollar corporations. When a handful of companies that control entire markets cheat, I'll say that again, when they decide to cheat, they can charge families more for groceries, rent, and everyday necessities, all while paying workers less. And for all of those considerations, we are proud to support this recommendation and appreciate how thoroughly you all have been. Thank you.
Is there any other public comment, question? Yes.
One online, Professor Robin Feldman.
Thank you. Are you able to hear me?
Yes, we are. Thank you. Welcome.
Thank you so much. I'm Professor Robin Feldman, University of California, Los San Francisco, and I appreciate the opportunity to speak today on the proposed antitrust amendments. As the prior speaker alluded, I believe markets should be free, fair, and efficient. In that context, consolidation in the abstract isn't necessarily bad, but if it strips the market of effective competition, then governments need the tools to respond, including the government of California. From that perspective, I'd like to focus on addressing an issue raised in some of the public comments concerning whether the proposed amendments will chill innovation in biotechnology. I believe, yes?
Professor Feldman, I'm sorry to interrupt you. I have a
Please,
question.
please.
Are you speaking to the mergers memorandum or the legislative program memorandum?
I'm speaking to the new, the proposed language for the merger. And forgive me for not being certain which of the technical ways to answer your question, but it's the one that, for example, concerns the rebuttable presumption of using the HHI index.
So
judging.
Yeah, sorry to interrupt again. We are currently not on that item.
I'm so sorry.
But we think we'll get to it after lunch.
Wonderful. Well, I'll wait with you, and I apologize for interrupting you.
Okay, thank you.
Thank you so much.
So, okay, any other public comment on this technical change? Hearing none, seeing none. Any other questions or concerns from commissioners? Seeing none. Is there a motion to approve? I believe Senator Reyes moved. Is there a second?
Second.
Been seconded.
Okay.
Call the roll.
Commissioner B.
Aye.
Commissioner Carrillo.
Aye.
Commissioner Kubas.
Aye.
Senator Gomez Reyes. Senator?
My apologies, I keep.
That's okay.
Aye.
Thank you. Commissioner Jenkins, are you voting on this?
Since it's technical changes, I'll vote aye.
Okay, thank you.
Thank you.
And Commissioner Simpson.
Aye. Okay, now we're on to item 5, terminology relating to persons with disabilities. Sarah?
Good morning, Commissioners. I'm presenting Memorandum 2026-9 related to persons with disabilities. To recap, the legislature asked the Commission to recommend a term to replace the phrases dependent adult and dependent person throughout the codes with new terms describing these persons in a more respectful way. The directive further requested that these changes be made in a consistent and comprehensive manner that does not substantively change existing law. This memorandum considered the language of the original bill directing the study, replacement options suggested from the working group, and discussions with Legislative Policy Committee staff. Among the reasons discussed in the memorandum, the staff believes person with a disability is an appropriate replacement for dependent adult or person because there is significant overlap between the definitions of dependent person or adult and person with a disability. The staff also believes it would be less disruptive to the codes to add additional definitions to a phrase that already has multiple definitions than creating a new and unfamiliar phrase with multiple definitions. The staff is asking if the Commission wants the staff to explore replacing the defined and undefined terms dependent adult and dependent person with a disability. And this will require us looking at each section of code independently and making sure that it fits in context. Are there any
Okay,
questions?
and so this doesn't require a vote, but this is just, is there any concern about looking into this option further? Okay, any comments or questions from commission members? Seeing none, hearing none, any public comment? No public comment. So you don't need an action from us, but advising us that
There's nothing.
that we're kind of looking into this as an option to respond to the legislature's request about changing terminology that has some concerns.
Exactly. And if the commission has any other suggested terms, we're happy to look at that as well.
Okay. All right. If there's no further action needed,
Is there any public comment?
there was,
Oh, okay, sorry.
I saw the shaking of the head.
Okay, okay.
Okay, in that case, we'll move on to civil discovery improvements, item 6.
Sure, this one is me. So at the commission approved reactivating a study related to civil discovery improvements in December 2025. So this is the official reactivation of the study memo. The original work, which was done, I think, in 2017, discussed informal discovery conferences among several other discovery related topics. In the process of looking at this back in 2016, 2017, there was a bill introduced by Assemblymember Chow, who was also a member of the commission at that time. And that bill, AB 383, was enacted into law with a repeal date of January 1, 2023, and it specifically applied to informal discovery conferences. So this portion of the reactivated study is focusing on AB 383's impact and a potential recommendation on whether its provision should be reinstated with or without changes. So turning to that, we did have some background on pretrial discovery that is hopefully helpful in understanding what this is all about. But getting into AB 383, some courts found the existing discovery processes insufficient and began holding informal discovery conferences so that judges could supervise the pretrial discovery process. The AB 383 was enacted to implement what several courts apparently had already been doing. Like part of the thought was it could help facilitate the civil discovery process, and when things when parties weren't able to reach an informal resolution through the meet and confer process. So we have some background on that, and pages 4 and 5 and what the Judiciary Committee analysis stated. So as I stated earlier, that bill did sunset a couple years ago. There was a bill that looked like it was intended to reinstate the language. However, that was just the introduced version of the bill, and it was later amended to apply to something else. So there hasn't been a lot of thought about it, at least as far as I'm aware. Since then, the staff has done a little bit of informal outreach to some of the stakeholders, and it appears that there is interest in revisiting AB 383 and whether it was the best practice. So the staff proposes broad stakeholder outreach to learn about the experience of courts and litigants with AB 383 to determine whether the goals of the legislation were met, any improvements could be made based on that experience, and whether courts have continued to use the informal discovery process after the sunset of AB 383. If any of the commissioners have suggestions about other things that the staff should focus on, we'd love to hear that. And as indicated in the memo, we do plan to do broad outreach. We do have a judiciary and civil procedure mailing list for this study. I think it's somewhat outdated. I went through it and I could myself looking at some of the names, I realized, oh, that person from Judicial Council retired. So we're gonna need to update that. And so we're going to do outreach to a number of different organizations, including the state bar, county courts, law school professors specializing in civil discovery, et cetera, et cetera. We'd love to hear if the commission has any suggestions on other folks we should reach out to. So the question for the commission is, does the commission agree with the approach outlined in the memorandum or have other suggestions?
So, number one, since I'm not a lawyer, don't know anything about this process, there was a statute that for some years created an informal process for getting civil litigants to try to work out their discovery issues. It sunsetted, and now the question is, should the commission sort of look at how that worked, and should it be put in statute permanently or with modifications, kind of how that worked?
Yes.
That's basically it. And secondly, to reinstate the study and to do this, now look at how it worked and the changes, that requires a vote?
Yes.
To do that? Okay. Got it. Any questions or comments from commission members?
I'm fine with this.
We had a suggestion for.
Oh, great.
Outreach.
Okay.
The American Trial Advocates.
Okay. Great.
Suggestion? Any other comments or questions from commission members? Seeing none. Any comments or questions from the public? Seeing none. Is there a motion to reinstate the study?
So moved.
It's been moved and double moved.
Second. Second.
Okay. Call the roll.
Okay. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas.
Aye.
Is the senator still on? I do not see her. Okay. Commissioner Jenkins
Aye.
and Commissioner Simpson.
Aye. All right, the hour of 11:30 having arrived. We'll, I think now would be a good time to recess for lunch. And to reconvene, say 12:15? 12:15. I know Commissioner Kubas needs to leave us around 1. Right back south, so we try to get as much as we can done on the antitrust before that time. Yes.
Would it be better to push through to the antitrust now?
Well, what do people think?
Yeah.
Keep going? Keep going, yeah? Kara? Well, you're not. Are you gonna
Sure.
participate in the discussion or?
I mean, I'm not going to vote on anything, but I could listen in.
I can go till noon.
What's that?
You can go till noon.
You can go till noon? And then are we losing you at noon?
No, I just need a sandwich.
At noon.
Okay.
So maybe what you could do is start with a presentation and take public comment after that, and
Okay.
after lunch, sorry.
Okay, let's do that. Antitrust.
Okay. It's good afternoon. I'm going to present memorandum 2026-14 and its 3 supplements relating to the draft options for mergers and acquisitions. Last meeting, the commission asked the staff to prepare further options for merger language based on the options presented in prior memorandums. And because they continue to form the base for the current options, I'll briefly refresh.
Okay.
So the first option most closely mirrored the federal Clayton Act. The commission, however, at last meeting decided to no longer consider this option, so that one's off the table. Option 2 takes the basic language from option 1 and then adds the structural presumption from United States versus Philadelphia National Bank, which determined that a merger between 2 banks that resulted in a combined 30% market share is a highly concentrated market and substantially lessened competition, thereby violating the law. Many individuals believe the reasoning in Philadelphia Bank established the correct thresholds for determining competitive harm, which was closer to a reasonable likelihood rather than the arguably current standard, which is closer to, well, probably cause harm. Placing this language in the proposed statute signals that a merger that results in a 30% market share is presumptively illegal unless the plaintiff can provide evidence clearly showing that the merger is not likely to have anti-competitive effects. Philadelphia Bank has not been overturned, but many argue that courts have since placed less weight on a plaintiff's initial showing of concentration and instead require a higher burden of proof to establish competitive harm. And I'm looking to Cheryl to jump in. I didn't misstate anything. The intent of including this language is to reset, but while still being able to rely on some federal jurisprudence around Philadelphia Bank and its progeny to interpret California's merger regime. And this option also references the 2023 federal merger guidelines as persuasive authority. And option 3 built on option 2, but instead of referencing the 2023 federal merger guidelines as persuasive authority, it integrates the specific portion of the guidelines that was intended to reflect the holding in Philadelphia Bank. And the guidelines use a test based on the Herfindahl-Hirschman Index, also known as HHI, which is a widely used tool to represent the level of concentration in a market. And the commission last meeting asked for further information on that, and I included that in the memorandum. But very briefly, the HHI is defined as the sum of the squares of the market shares. And it's small when there are many small firms, and grows larger as the market becomes more concentrated, reaching 10,000 in a market with a single firm.
Can I ask you a quick question? Is the HHI of all the firms in that market, or is it of the firms who are proposing to merge?
It's the firms in the market.
The whole market. And so you would look at what's the HHI before the merger, what's the HHI after the merger? Okay.
To determine the increase
In-
caused by the merger.
Got it, okay. Thank you.
The including the 2023 federal merger guidelines with this bright line test arguably makes it more straightforward to determine what constitutes a problematic merger or not. Option 4 changes the standard by which mergers are evaluated altogether. It modifies may be with appreciable risk and replaces substantially with more than a de minimis amount. And together, these are intended to reduce the burden of proof necessary to prove an illegal merger. So bring it back to arguably what the original Clayton Act was intended for. Also last meeting, the commission heard an idea from Professors Lambe and Newman and former FTC Commissioner Slaughter, and for ease, we're just referring to them as the antitrust authors, that would reinforce the second prong of the Clayton Act or tend to create a monopoly by splitting it from may be substantially to lessen competition. And this was to target sort of serial roll-ups and other smaller mergers that might necessarily impact the market as a whole, but it does impact the competitive situation.
And that splitting those issues shows up in options 2, 3, and 4, correct?
Yes.
Okay.
And actually, you'll hear further from Professor Landy about this idea. In drafting these revised options, the staff reached out to the antitrust authors with a question about how the Philadelphia Bank presumption would apply to the split, because the Philadelphia Bank directly only really applies to the first prong. So the professor will be available during public comment to present on his thoughts on that. So the staff did not directly address this issue in the memorandum, instead for waiting further explanation from the experts. And now I'm going to speak to the options that the commission directed the staff to prepare for this meeting based on those original options. So revised option 2 remains largely the same as before, except the first subsection is divided in 2 pursuant to the antitrust author's idea. So as you said, revised option 3 builds on new option 2 by adding the HHI standards from the 2023 Federal Merger Guidelines, and also declares that the 2023 guidelines are persuasive authority. And then option 4 builds on option 3, so this is just a giant antitrust snowball, but changes the standard and ties Philadelphia Bank to that new standard, and also includes the HHI guidelines and references the 2023 Federal Merger Guidelines as persuasive authority. Finally, the memo also advises the commission that the purpose statement adopted for the single firm conduct recommendation would also work for mergers if the commission would like to enable some sort of cross-reference. Finally, the public comments and supplements 1 through 3 were evenly split between supporting and opposing these new options, and they echo similar comments sent previously from the same groups.
Okay.
Mr. Chair, can I ask a technical question?
Yep.
Looking at page 8, the last full sentence before the block quote in the text, it starts, there are additional agreements that this merger guideline, should that say do not necessarily reflect?
Yes.
Okay.
Thank you.
Thank you.
And the Professor Landy will be ready in about 5 minutes.
Okay.
So do we have any further questions from the commissioners, or should we
Yeah,
take
can
other
you,
public comment?
Just make sure to point out for me in, I think it's in options 2, 3, and 4, where in the language it moves from current federal law to the Philadelphia Bank decision.
So in 2, 3, and 4, Philadelphia Bank.
It's in A and B, or A, B, and C?
It's in C.
It's in C.
So A and B are modeled on the original Clayton Act language, and C is Philadelphia National.
A and B, but it changes from the current federal law by bifurcating the issues of
Yes.
monopolization versus lessening competition.
Exactly.
Okay.
But because kind of the point of 4 is to change the standard, Philadelphia National happens and is represented in subdivision C.
See,
But instead of the phrase substantially to lessen competition, it's replaced with create an appreciable risk of lessening competition, which is also mirrored in subdivisions A and B.
in option 4.
Yes, option.
Okay, so is Philadelphia National Bank holding embedded in option 2 and 3 as well?
Yes, but Philadelphia National Bank retains its original language that was decided on the may be substantially to lessen competition. So the last version is taking that operative language and substituting with the new language.
Right. Okay, so let me just, maybe it's a techie issue in option 2, subdivision A. About the 4th line, 5th line down. Rather than saying maybe to substantially lessen competition, it says maybe substantially to lessen competition. Is that a technical?
Rick, can I jump in? I had a related question.
Yeah.
So, on page 2 of memo 14, so my related question is, it seems to me like the purpose that the drafting is attempting to achieve here is to reinstate the reasonable probability or reasonable likelihood of competitive harm standard. And so where my comment links up with yours, Rick, is that I think that's substantively different from the text you just identified in A, maybe substantially to lessen competition, and parallel language in C, deemed to substantially lessen competition. I think there's a substantive difference between that and a reasonable probability or a reasonable likelihood. So correct me if I'm wrong, like the intent here is to take that reasonable probability concept and put it in this language. If that's the intent, I'm not sure that's been done.
Are you speaking to option 4?
Any of them.
Oh.
Well, if you
okay.
look at option
So
4,
I just control F reasonable probability and reasonable likelihood, and they're nowhere in any of the options. So if that's specific text, if those quotes, and they were in quotes on page 2, if that's not anywhere in the language, then where is it? And why isn't it quoted?
Oh, I apologize. The reasonable probability, reasonable possibility were, I should have cited those. Those were 2 commenters. That's not actually in Philadelphia Bank. So
my question is still, is the intent to take that concept, regardless of how it's exactly phrased, and put it in any of these options?
yes.
Where does it appear?
I think that's an option 4.
Only in 4.
No, so there's an argument. So options 2 and 3, by quoting Philadelphia National Bank, the actual operative language, which is a merger that may produce a firm controlling an undue percentage share of the relevant market, shall be deemed to substantially lessen competition. That is the structural presumption from that case, and by including it, the idea is that the bar will be reset to the cases in that era that had a lower burden of proof.
Well, I think that what Philadelphia National Bank and its operationalization through guideline 1 do is change the burden of proof in a merger in a very concentrated market. Otherwise, I don't think of Philadelphia National Bank as changing the burden of the standard of liability. Philadelphia National was interpreting the Clayton Act as it existed at that time. So Philadelphia National, both in the general formulation that appears in every one of the options, as well as in the merger guideline formalization of it, which appears in option 3, really go to a shifting the burden of proof in the concentrated markets.
Yeah, I got that part. I just wasn't clear on what the initial burden of proof is that we're defining whether that links up with Philadelphia National, and whether that's different from anything currently existing.
So A and B set forth the existing standards of liability, and they closely parallel the Clayton Act.
So what about C?
Oh,
No,
so
C represents a general restatement of Philadelphia National Bank's language.
so the
So
argument,
do you see, or do you share my concern that there's a substantive difference between something that's likely to have an anti-competitive effect and something that's reasonably likely to have such an effect?
so the argument is that the cases after Philadelphia National Bank, without any change in language, moved that probability on their own.
Yeah.
So the argument is to recenter with Philadelphia Bank to, in addition to the purpose statement, to reduce that standard or reduce that probability.
I think I'm still confused about what the intent is here. If the intent is to back away from the arguably wrongly higher burden of proof that federal courts are currently imposing, the language that's in subdivision C on page 4, it doesn't seem to me to do that. In fact, quite the opposite. It's very amenable to a reading that's consistent with that arguably wrongly higher standard of proof that's currently in federal law. So if the intent is to lower it, why aren't we being explicit about that?
And that is actually the exact argument for the individuals who are in favor of option 4, which actually does change the standard. Yes.
It's only option 4 and the use of the appreciable risk that attempts to kind of reset the liability standard to what some people say was Congress's intent in enacting the Clayton Act in 1950.
Right.
And option 2 and 3, on the other hand, lay the foundation of the liability standards that closely parallel the Clayton Act, and then they change the burden of proof in those cases in concentrated markets that increase a lot of that increase consolidation significantly.
Okay. I think I understand now. Rick, I apologize for hijacking your question.
No, that's okay. So back to my question. Is the wording in subdivision A of option 2, and I think option 3, correct? May be substantially to lessen competition, or should it be maybe substantially to lessen, or maybe how is it? Deemed too substantially lessen. Is the substantially the measure of how the probability of this lowering competition, or is it the amount of lowering? One's a probability and one's the effect.
I believe that substantially is the amount and the may is the probability, right? So the appreciable risk is changing the probability, and the diminished amount is.
But this then should say may be to substantially lessen competition, as opposed to may substantially to lessen.
It's just weird, but that's just what the Clayton Act says.
But that's not what it says in subdivision C. In subdivision C, it's deemed to substantially lessen competition.
Correct, and that's also the language from.
Really?
Yeah.
That's weird.
I agree.
Okay, and help me make sure I understand that this subdivision A and B distinguish lessening competition as the evil thing that's happening versus creating monopoly or monopsony as the evil thing happening, right?
So
That's A and B.
Yes, so A and B, we're gonna speak to the author on this a little bit more, because I think things may change a bit, because the original argument was that breaking A into A and B didn't really do anything different, just really separated them. But then by adding subdivision C, if the commission wants to reference Philadelphia National Bank, which is entirely up to you but not necessary, Philadelphia National Bank only speaks to prong A, not B. So it's a little odd.
Okay.
B is just kind of hanging out there.
Lessening competition as opposed to creating monopoly or monopsony. Okay. And so the difference between A and C is the acquisition may substantially lessen competition, and C is the merger has a significant increase in market concentration. Those are the, is that two different?
C applies A.
C applies.
So A is the standard and C says, if this happens,
Substantially lessening competition
Right.
means increasing concentration means lessening competition. Is that what?
it's,
That's what it says?
yeah, so it refers to, so that this language is meant for people to understand that this case is from Philadelphia National Bank. So when it says a merger that may produce a firm controlling an undue percentage share of the relevant
Right.
market. In that particular case, it was 30%.
Yeah,
So
I know
that's
that.
what Cheryl's referring to with the structural presumption. So that is interpreting subdivision A, which says it may substantially lessen competition. Then you go, oh, C says 30% does that. So that's how that works.
So C uses Philadelphia Bank to create a measure of, uses a measure of concentration to determine whether you're substantially lessening competition.
Correct, with some wiggle room though, because by referring to the case itself said these factors, it's doing it squishily. So, and we have the professor is joining us.
Okay.
Cheryl, did you have something to add to that?
Yeah, I think of Philadelphia National Bank as kind of setting a general guideline as to when we're gonna change the burden of proof from the government or the challenger to the merger to the merging parties, and when they have the burden of proof. As opposed to changing the burden of proof or deciding when the merger is unlawful. It's just a mechanism to switch the burden of proof. It creates a presumption.
And that's based on the amount of increased concentration.
Right, and it's expressed in very general terms
Yes.
that are taken directly from the case in paragraph C.
Right.
And that's why, and those terms could engender a lot of litigation. I mean, you could litigate about what is an undue percentage.
Right.
You could talk about whether there is a significant increase in concentration, which is why we have in option 3, what the FTC and the DOJ have decided is a more quantifiable and straightforward definition of when that presumption actually arises. Metrics to say, okay, this is where we're going to change the burden of proof.
Okay. Thank you. Didn't mean to be wonky.
I have a question
Yeah.
before we,
Yeah, Maria.
so I saw in the report though that section C, there's a footnote that says the sentence will not be included. It'll be in a note or a comment.
Yeah, so at the end, we were talking with a number of different stakeholders and we were looking at the different changes to things. The staff doesn't think that you need to reference US Philadelphia Bank in there since it's generally fairly well known, but if the commission would prefer that might be back there, we don't believe it substantively changes anything.
Okay. And then my second question is, if we did not want to use an entirely new standard like appreciable risk, would it make sense to add the reasonable probability or some reasonableness standard into option 2? Because it would be new, but reasonableness is really foundational to civil law.
I think the intent of option 2 is to not introduce a new standard. And that introducing the new standard is presented by option 4. So these kind of build on one another. This is kind of the building block in option 2 and a general expression of Philadelphia National Bank, which is existing law. And then the next option builds on that by operationalizing that presumption and giving it some teeth by giving it some metrics that are understandable and that will reduce litigation. And then option 4 is the vehicle by which you try and change the standard, whether you call it a new standard or whether you call it recapturing the original intent, is the two sides of the debate.
And staff was trying to present the commission with various options that included more conservative drafting to address people's concerns that too much too soon may just be disruptive. But as the Commissioner Carrillo noted, if you are copying federal law, it is assumed that you're bringing all of federal law with you. And perhaps to counter that, we suggested that the purpose statement could be introduced, but again, this doesn't make anything happen. And if you don't think that that would be sufficient enough, then there's the option for a whole new standard, which of course could also be partnered with the purpose statement as well.
So maybe to get to what Commissioner Carrillo mentioned early on, one could take option 2, and rather than having the maybe substantially lessened competition, which is for the current standard, could one substitute either what he said about what reasonable probability or reasonable likelihood, or in the alternative, the language from option 4 that says create an appreciable risk of lessening competition more than a de minimis amount.
Sure.
That's an option as well. Without the, I'm kind of nervous about the HHI stuff, honestly, but
Yeah. Can I jump in, Rick?
yeah.
My suggestion was going to be sort of similar, going in the same direction. I would work in the direction of option 2. I would clarify subdivision C and make it explicit that the quantum of proof required is a reasonable likelihood that's how you define substantially lessening competition. That's how you prove that competition has been substantially lessened. I would also include the provision about linking to our single firm conduct, disavowal of federal laws controlling that it's persuasive only. And then I'd make the HHI analysis a factor in determining the reasonable likelihood of whether competition is going to be lessened. But I wouldn't make it the key question on whether that likelihood exists or not.
So would you prefer that the HHI not be included explicitly, but you?
I wouldn't spell it out. I think you can do it in like C sub 1 if you want, or just add it into C that analysis is relevant to the discussion or relevant to the analysis of the reasonable likelihood, but it's not dispositive, or it's not.
Yeah, you could put it in something maybe in a generic way in subdivision D. Interpreting the section, the merger guidelines shall be considered persuasive and understood to. You could maybe put something.
Yeah. So I think it's interesting and it's probative and it's relevant to the analysis, but it shouldn't be the only discussion, because as I think some of the commenters have pointed out, all that does is move the battle to defining the market.
Right.
Which encourages gaming, which we don't want. And I'm also a little worried that this has the same problem as the market dominance standard, that it sets an arbitrary number, and which just sets the battle around whether you're above or below that number. And again, it encourages gaming. But it's not irrelevant to the analysis. So I would include it. I just wouldn't make it dispositive.
Would you include something more specific than D, referencing the guidelines generally? Would you want D further clarified to reference the HHI metric specifically?
Correct me, do the guidelines reference HHI or do they rely on them?
Yeah, HHI is
Okay.
derived, it's
Well, then-
one of the things in the guidelines.
Oh, okay.
Well, then I think that incorporates it. Rick, do you
Yeah.
agree?
Okay.
Yeah, that makes that available. I mean, so going in the other direction, like my problem with something like option 4, aside from the, Chamber of Commerce argument that it'll flip the table over, is I think it sets the burden of proof too low at the first stage on the plaintiffs. More than a de minimis amount is more than almost nothing. It's trivial. I think it's too easy to make that showing. The problem with option 2 as it's written, though, is it doesn't define what the showing is. And by including the quoted language that's earlier in the memo about reasonable likelihood or reasonable probability, one of those two, I think they're interchangeable. I think clarifies the ambiguity that's in C, and it makes 2 the viable option.
Could I ask Cheryl, is reasonable probability or reasonable likelihood, is there case law around that?
Well, I think you're using that as a substitute for appreciable risk. And I think people have used a lot of different terms for appreciable risk. This comes from federal legislation, the Calera bill, has a lot of the commentators have kind of focused on that language as opposed to reasonable probability. And I just want to go back to the use of HHI. The HHIs in option 3 aren't used to determine liability. All they do is to set a threshold at which you turn the proof of whether the merger is anti-competitive. So they don't
I get that.
affect the standard. Okay.
I get that. It goes to the plaintiff's additional burden of proof. And again, I think it's relevant to that analysis. I wouldn't want to make it the hill on which everybody has to die.
So in terms of the standard, I hear you saying that like the appreciable risk or reasonable probability, but you don't like the de minimis. So I mean, that is
Right.
obviously you could drop that and say an appreciable risk of substantially lessening competition.
Yeah, if appreciable risk is the term of art, fine. Especially if you think that that's interchangeable with reasonable probability.
On that, just to make sure I understand, the appreciable risk, reasonable probability deals with the likelihood of the bad effect happening.
Right.
Under the current language in options 2 and 3, how bad competition is reduced is the substantial.
Right.
Right?
Right.
And if we don't like de minimis, and we think substantially isn't bad enough, it has to be really, really bad. Is there something that because I'm kind of persuaded that making the likelihood of bad effect happening reasonable, or something like that makes sense. But do you want to also affect how bad the anti-competitive effect is? Because you could have high probability of a low effect, low probability of a very high bad effect. And so do you want to, how do you modify the two things to kind of go forward with? If it's not in a de minimis amount, which I think as Commissioner Carrillo said, that could be, a little bit bigger than 0.
Yeah. Mr. Chair, can I suggest that we noodle that over lunch?
Okay. Then we have, our professor is, somewhere, it looks like in paradise, waiting for us to, call on him. Can we?
Yeah.
Do that? Yeah, Professor?
Sure. Yeah. Can you hear me?
Yes.
Okay. I'm only prepared to speak about the presumption issue, not the choice of the four paragraphs. If the timing is right, I'd be delighted to talk. Yes.
Is that
He's going
the
to speak.
presumption meaning?
The Philadelphia National Bank presumption issue.
No, this was about splitting A and B.
Oh, okay.
And how Philadelphia kind of really just related to A.
Okay.
Sure.
Fire
Sure.
away.
Sure. As everyone, I'm a big fan of the Philadelphia National Bank presumption. As people may or may not know, it was originally devised by Richard Posner when he was a clerk on the Supreme Court. He devised it, sold it to his justice, who sold it to the court. And recently, Judge Posner said that's the way to do it. You've got to have a presumption. Otherwise, merger law becomes unpredictable, unending mush and chaos. And I agree with Judge Posner. It's the best way to structure merger law. If we are going to have a presumption, I have four suggestions for ways to polish the presumption as it was worded in a draft that I saw. And I'd like to give you my four suggestions. First, I think the presumption should apply to both of the paragraphs, to both of the operative banning paragraphs. The may be substantially to lessen competition paragraph, and also the may tend to create a monopoly paragraph. And I think the presumption paragraph should follow the two banning paragraphs. Second, I think the paragraph should make it clear that for the merging parties to successfully overcome the Philadelphia National Bank presumption, the burden of both producing the relevant evidence and also the ultimate burden of persuasion that the merger clearly does not violate the statute should rest on the merging parties. This distinction is important because some court decisions have distinguished between the burden of producing the evidence from the ultimate burden of persuasion. One example, which I'll be glad to read from or send you a link to if the commission's interested, is an opinion by then Judge Clarence Thomas. Clarence Thomas does just what I was talking about. He holds that the Philadelphia National Bank presumption at most includes producing the evidence, but does not affect the ultimate burden of persuasion, which then Judge Thomas says is always on the plaintiff. I think that the presumption paragraph should make it clear that a merger will be enjoined unless the merging parties both clearly produce the relevant evidence and also that they clearly persuade the court that the merger produces no appreciable risk, that it may substantially lessen competition, or that it may tend to create a monopoly. A third suggestion I have is that the presumption paragraph should make it clear that the ultimate standard is that the statute will prohibit mergers that may substantially lessen competition and not use the is likely to substantially lessen competition that is now used in the draft presumption paragraph. And finally, I'm afraid that the next chance it gets, the U.S. Supreme Court will eliminate the Philadelphia National Bank presumption. If the Supreme Court should eliminate the Philadelphia National Bank presumption, then, and if California explicitly names the Philadelphia National Bank case in its statute, I fear that future courts could misinterpret the California statute as having intended the post-Philadelphia National Bank U.S. Supreme Court case law. So I put my four suggestions together and put them in a paragraph which I gave to Ms. Hutchell, I don't know if she was able to get it to the commissioners. Yeah, the lower paragraph. If I could just read the lower paragraph to you, and then I'd love to discuss it. If a merger may produce a firm controlling an undue share of a relevant market and may result in a significant increase in the concentration of firms in that market, or the merger may tend to create a firm with near monopoly or monopoly, then the merger shall be held to violate this section unless the merging parties produce evidence clearly proving that the merger poses no appreciable risks and that it may substantially lessen competition, or that it may tend to create a monopoly. So I would love to answer questions or discuss this.
Mr. Chair, I'd like to move that we break for lunch and take this up afterwards.
Okay, Professor, thank you. Are you going to be around after lunch?
Absolutely. Just tell me when and I'll be happy to join back. Sure.
Okay. With that, since we lost Carrillo, why don't we break for lunch, come back at 12:45 or 45?
Okay.
All right. Thank you all, and we have lots to study during lunch.
Thank you.
Yeah.
All right. Welcome back. The Law Revision Commission is back in open session. We may not have any more legislative members.
Are we missing Anna?
If not,
Yeah, she had to leave. So
Do we still have a quorum?
at the moment, no. At the moment, we just have 3 voting members. If both of the legislative members join us, we will have a quorum sufficient to vote. In the absence of that, we can certainly give direction to staff in terms of moving forward on this stuff.
Yeah, based on what we've heard so far, it seems like the commission would benefit from further analysis of some of the discussion.
And did you want to talk with Professor Land
Yes,
further about?
Yes. So Professor Land, welcome back. You look like you're we can't hear you.
Can you hear me now?
There you go. Yep.
Thank you so much. Thank you. Thanks for having me.
Mediterranean or something, are you?
That was actually from Thailand, but yes.
Okay.
Yeah. Nice vacation.
Great. Okay, welcome back.
Thank you.
And we were just gonna hear from you, I think, about.
Yeah, I think you already presented,
Oh,
though,
okay.
at this point, it would be whether the commissioners have questions.
Yeah,
Can we put the language back up? Or
Sure.
I sent-
Yeah, you wanna
put
put-
on email too.
oh,
I mean, unless you want me to talk a little bit about the issue of a separate paragraph for maybe substantially to lessen competition versus may tend to create a monopoly, I'd be happy to talk about that if you like.
I think we'll wait on that.
Okay.
You wanna do that?
Okay.
to you.
Well, no, go ahead.
Yeah.
Yeah, go ahead.
Oh,
Yeah.
My co-authors and I did a study of every federal merger decision during a 10-year period. We found 26 federal cases that relied on the maybe substantially to lessen competition clause, and 0 cases during that 10-year period. Not one single case relied on the may tend to create a monopoly clause. There are older cases, older Supreme Court and lower court cases that have relied on the may tend to create a monopoly clause. But it's been largely ignored in recent years, and we can only speculate why. But we would like to give it more emphasis, not just to leave it as the stepchild of the statute. And we thought that by putting it in its own separate paragraph, that would tell people this is something that should be separately considered. It's a separate issue that deserves separate emphasis.
Okay,
And that's reflected in the
and that's
statute.
reflected in options 2, 3, and 4.
Correct.
Correct?
Correct. That's correct.
And just so I am clear, subdivision C, which is a different variation is the one that Professor Land has, is the one that, is that the one that's burden shifting? Is that,
It's this, yes.
okay.
Right.
And so A and B are two different characteristics of unlawful action.
Yes.
And C is if the
The
merger,
burden shift.
merger if the merger is sufficiently bad, then it shifts the burden.
That it shifts the burden of proof, the burden of production of evidence and the burden of proof. This was Judge Posner, his creation, his inspiration as a way to simplify merger analysis, as a way to stop it from becoming a swamp, an unpredictable swamp. And he thought of it while a clerk sold it to the Supreme Court, as I indicated earlier, and 10 years ago said this is the way you should have merger enforcement. He's also very skeptical, talking about Judge Posner, of efficiency claims in mergers. There's a wonderful quote by Judge Posner: "I wish somebody would show me efficiencies from mergers. There must be some." And when you start with a background of skepticism on merger efficiencies, then you want a strong presumption that if it's a really concentrated merger in a really concentrated market, we presume that it's anti-competitive, unless they can show it's not because of easy entry, for example, something like that. And the original formulation of Philadelphia National Bank, as you know, said these mergers will be blocked unless defendants can clearly show that the concentration and increase in concentration evidence isn't dispositive. For example, entry is easy. That's the way Philadelphia National Bank presumption started, but many lower court decisions have pretty much just ignored it. And I read you a little bit from a Judge Clarence Thomas opinion that basically sidestepped it. It was amazing what a circuit court judge can do if they want to. They can ignore a Supreme Court decision. So I urge this this commission to reinvigorate this presumption and to put a strong version of it in the California anti-merger law.
Okay, thank you. And I think Commissioner Carrillo was going to say something. No?
Yeah, thank you. So I'm hung up on the burden of proof, Professor, and I want you to imagine that I am not nearly as well educated as you are, trial judge, and a plaintiff comes in front of me and is trying to block a merger. What quantum of proof do I require from the plaintiff in terms of the initial burden shifting showing?
You have to define a relevant market, which, as you pointed out earlier, is almost always a dogfight. Okay,
Yeah.
We're going to fight about market definition in almost every merger case I've been involved with. I used to prosecute for the government. I used to work for a firm called Jones Day, which was a defense firm. Every case I ever worked on in the merger area was a huge fight over market definition. You can't get around that. We're going to have a market definition fight.
Okay.
Then
So once
you've
we
got-
get past that,
Then once we get past that, then you've got market shares. We can use Herfindal's, we can use the Philadelphia National Bank approach of 30%. Then you've got the numbers. We crunch the numbers. Okay. And if it's, for example, as it was in Philadelphia National Bank, I forget the exact numbers, 15 plus 20, which is more than 30, so, something like that, then the burden shifts to the other side to say, but entry is easy in this particular case. So even though the numbers would suggest that it may substantially lessen competition or may tend to create a monopoly, because entry is really easy, we shouldn't block the merger. But the merging parties have to be the ones to show that, to produce the evidence, and then to show that entry is easy. And that's going to be a matter for the court to decide. They'll look at that evidence, and also the Philadelphia National Bank decision had the word clearly in it. Okay, so defendants have to clearly show that it won't substantially lessen competition or tend to create a monopoly.
Yeah, I see that part. What I'm hung up on is the plaintiff's initial showing that's required, and
so market definition plus high market share and high increase in concentration.
Okay,
and that should be the plaintiff's initial burden. And then we're going to presume numbers that high are anti-competitive unless, for example, you can show easy entry.
Thank you. I have no further questions.
So maybe if I can follow up on that, as suggested in your language, Professor, an undue share of the relevant market or significant increase in and a significant increase in concentration, that would be, in the absence of anything else, that would be up to the court to decide what an undue share is in this market, what a significant increase in concentration is in that market. Is that right?
That's right. Now they could use the Philadelphia National Bank numbers. I'd be delighted with those. They could use the federal Herfindahl numbers. I'd be, delighted with those. But that's right.
Okay. So that leaves basically, if you don't put that HHI stuff in the statute, then the court, probably based on nature of the market or whatever it is, would be the one that then determines whether there is sufficient potential anti-competitive harm to the merger to then shift the burden that the merging party has to show that it's not going to have a bad outcome.
When you put it that way, I guess I'd prefer that the numbers be put in the statute because I wouldn't want to have that vary from court to court. I'd like those numbers to be predictable. I want to maximize predictability. So I'd be delighted to use either the Philadelphia National Bank numbers or the federal Herfindahl numbers. I'd be happy with either approach.
But I'm not sure whether there is a right number. No, but anyway.
As the court said in Philadelphia National Bank, now this was a long time ago, I can't imagine they'd word it the same way today. We don't know where those numbers are, but this merger to more than 30% of a market surely reaches that threshold. So the court could use some approach like Philadelphia National Bank and actually give a number like a merger to more than 30% of a market, or you could put it in terms of Herfindahl's. I'm indifferent between those two.
I think staff mentioned this earlier, is that functionally what subdivision D is about in our language, like in option 2? In interpreting the section that 2023 merger guidelines shall be considered persuasive authority to complement.
Okay, that's fine. I mean, I don't have that one in front of me, but yeah, saying the merger guidelines, and if those, yeah, that would be fine. Sure.
And so, as it reads currently, in the revised option 2, depending whether you use the figure or some level of what Professor Land is mentioning, if you read that in conjunction with subdivision D, you could use the HHI if you want.
And in option 3, the numbers are actually part of the statute, and the HHIs have been used by the government to calculate how concentrated a market has been for decades. the thresholds of 1,800 for concentrated market and 100 for a significant increase have been used since the first guidelines were adopted in 1982, and they were used in every iteration after that, with the exception of 2010, in which those thresholds were moved. And then the FTC and the DOJ, looking back on those, decided that based on their experience and developments since 2010, that they should revert to the original historical HHI thresholds, which are reflected in Merger Guideline 1 and reflected.
Yes, and as you all know, the Democrats picked those numbers and the Republicans have kept them. So insofar as anything is bipartisan in the merger area, I think we can say that current merger guidelines are bipartisan. Let's take advantage of that.
Okay, I'm still a little nervous about merger guidelines changing
Sure.
going forward, and having a statute that, 5 years, 10 years down the road could be out of step with. That's why I'm kind of leaning more toward the generic expression of the
Okay. Right.
persuasive authority.
I understand, and that's a huge factor. On the other hand, predictability is also nice, and that's the advantage of saying we're going to use the federal Herfindahl numbers.
And I would also note that the intent of this law is to be overall different than the federal law. So even if you were to apply the federal guidelines, it may be different. There would be different outcomes as applied to California law.
Sure.
Okay. Yeah.
I mean, you could specifically reference the 2023 federal guidelines, and then if they do change, you still have the 2023 guideline numbers.
It does in terms of persuasive authority.
Right.
Yes,
Right.
it does.
Right.
Yeah, Maria.
So Professor, in section C, it says an undue share of relevant market. And in the original proposal, it said an undue percentage share, I think. Is there a significance to that change?
No, we didn't mean any significance. We just thought the percentage didn't add anything, but we're happy with either way, of course.
And then on appreciable risk, I think I saw some comments that there's an argument that may create confusion because there's not a definition for that the courts have used in the past. What do you think about that?
I mean, you're exactly right. Any new term we use could be litigated for 5 years, and that's a real problem. We couldn't come up with something better than appreciable risk. If you can come up with a term that the courts have already defined, we would love that. But we couldn't think of a better one.
And have the courts defined appreciable risk?
Not to my knowledge, no.
They did use it in the Ninth Circuit opinion in St. Albans.
Did they define it or just use it?
Well, they used it.
Yeah.
Yeah, that's a problem.
Yeah.
Yeah, it's all the substantial risk, appreciable risk, reasonable risk. They're all about what the likelihood of a bad outcome is.
Right.
And that's what I'm not even sure if I would necessarily conclude that appreciable risk is a lower percentage likelihood than substantial, well, maybe substantial, appreciable. I mean, that's how I'm sort of struggling with, it's a different word. And will the courts necessarily presume that it's a smaller percentage that they need to determine than who knows what some other word might be?
My my co-author John Newman and I struggled not to use the term appreciable risk, and it linguistically it's very hard. That is, we wanted just to focus this on the May standard. That is, the Clayton Act statute says if it may substantially lessen competition or it may tend to create a monopoly, then we block it. But then once you start wording it in the negative, okay, so the defendants are given an opportunity to show that it is not true that it may substantially lessen competition or it may create a monopoly. You can word it that way. It's a little bit cumbersome, if you know what I mean, because then you don't have to use the term appreciable risk, which could take the courts 5 or 10 years to define.
Right, but could someone say, well, yes, it does create an appreciable risk, but that's a risk of something less than substantially lessening competition. That what's the likelihood of this outcome and what's the magnitude of the negative outcome?
You're right. You're right. You're right. I can't argue with you. You're right. I mean, if there's any way to not put in the term either appreciable risk or any kind of risk, that would be better. I mean, it would just be a sort of a double negative. Unless the merging parties produce evidence showing that it is not true that the merger may substantially lessen competition, something like that, showing it is not true that the merger may substantially lessen competition or may tend to create a monopoly. That would eliminate the risk term completely.
And there's nothing easier at trial than proving a negative.
Right.
Well, yeah, but we want to put a presumption on the defendants. If it's a really concentrated merger, a big merger in a concentrated market, we want to put a heavy burden on the defendants. That's right. To show that entry is really easy, so there's no substantial risk of a lessening of competition or a tendency to create a monopoly. That's what we want, I think. At least I would argue. And that's what Judge Posner, that's how he designed the Philadelphia National Bank presumption. I mean, you want me to read you the Philadelphia National Bank presumption from 1963 just to refresh our memories? If that would help. Anyway, it's only one long sentence, and it says,
okay, yeah, go for it.
Specifically, we think that a merger which produces a firm controlling an undue percentage share of the relevant market and results in a significant increase in concentration of firms in that market is so inherently likely to lessen competition substantially that it must be enjoined in the absence of evidence clearly showing that the merger is not likely to have such anti-competitive effects. You could just repeat that language, although I would urge you to add or.
Yeah, that's what subdivision C does. So like reading that out of the case doesn't help because that language is already in proposal 2, subdivision C.
Okay. In the absence of evidence clearly showing that the merger is not likely to have such anti-competitive effects.
Yeah, that's on page 4. I'm looking at it.
Okay, so that would eliminate the reasonable, likely, the appreciable risk idea, which we all can have trouble defining.
I disagree. I don't think it does at all. Because you still have to determine how likely that is to come to pass. Right now, the language says may produce, which,
right.
Anything's possible in theory. Is that a 1% likelihood? 0.5%? 99%? I mean, good luck getting a trial judge to wrap their brains around this. If the goal here is to produce certainty, this does the opposite of that. And that's where I'm hung up on this.
Well, but any of the terms will produce uncertainty. Appreciable risk, may. I mean, we just have to center around a word that we feel the most comfortable with. And may is already in Philadelphia National Bank, so it has that advantage. Appreciable risk, we'd have to start over and spend 5 or 10 years defining it. Whereas if we just stick to may, well, that's the one we've been using.
Okay, if there aren't any other questions at the moment, why don't we move to public comment? And how about folks in the room? Best. One. Welcome back.
Do I need a microphone or are we good?
No.
All right. Good afternoon, Chair Simpson and Commissioners. My name is Ben O'Brien, and I'm here on behalf of California Life Sciences to express our continued concerns regarding the draft merger and acquisition proposals outlined in memo 2026-14. California Life Sciences represents over 1,300 pharmaceutical, biotechnology, medical technology, and academic research institutions across the state in a mission rooted in advancing innovative treatments and improving health outcomes for all Californians. This is precisely why we're concerned that these proposals present existential risk to our industry and the ability for patients to have access to the latest and greatest treatments at an affordable price. More than 90% of our member companies employ fewer than 10 people, and 70% fewer than 4. These are small teams of scientists and researchers whose true passion is discovery. They operate at a loss for years, betting everything on a single breakthrough. For them, M&A is not a hostile takeover. It is often exactly what they're working towards. A successful acquisition allows these innovators to realize a return, reinvest in their own next research venture, and restart the discovery pipeline. While the treatment they work so hard to develop gains access to combined funding and resources needed to navigate the regulatory process and ultimately reach patients. That's how the life sciences ecosystem works, and these proposals could put that cycle at risk. I know given the discussions today that things are kind of moving around a little bit with what's going to be in the different proposals and what options kind of will remain. I think given the discussion that was just being had, I think we would have a concern around this proactive or having to prove a negative. So trying to again, like you were just discussing, proving that a merger proactively is not going to create whatever standard you see may or appreciable risk. A lot of the life sciences markets are often inherently concentrated and present some kind of different navigational things that might need to be considered when setting up these different standards and how different businesses would be classified within that, particularly noting just like potentially a lack of experience and justices dealing with those types of businesses and potentially being lumped in if we're automatically hit over a rigid threshold without kind of a deeper understanding of the market dynamics there. So I kind of will refrain to make kind of specific comments on those options because I know they're kind of in flux and we'll see kind of how they are. We do have a comment letter that has some more specific feedback on the options as they were drafted before today's discussion, but I don't know if that's necessarily helpful if you're moving in a different direction from where those are today. I will just close by saying we believe that California already has enforcement tools. The Attorney General can enforce federal merger law directly. And starting in 2027, we'll receive all Hart-Scott-Rodino pre-merger filings, giving the state real-time visibility without displacing the federal framework. We believe this is meaningful and targeted upgrade to California's current oversight capacity related to M&A, and that we should let that work before layering on untested standards. I just want to close with a quote from the letter submitted last year by a majority of the M&A expert working group. In their response, they write, "We believe that consistency with federal merger law is of primary importance. Neither consumers nor businesses benefit from a fragmented collection of statutes regarding acceptable mergers and acquisitions." So just ask the commission to consider those comments and the comments we've made here, addressing our concerns, and appreciate the opportunity to continue to work on this together. So thank you.
Are there questions or comments from commission members? I kind of have one, maybe a question for Professor Land. I was thinking about the issue that this presenter made about sort of nature of the environment that these pharmaceutical companies and whatnot have. And it doesn't sound like it's the same as, the environment where, companies are competing, in making laptop computers or something. Do courts take into consideration things like the nature of the quote unquote market, what a market is, what if it's a drug manufacturer and they produce, a particular drug that is very effective against some disease and they get whatever licensed by the department, the federal, people. I mean, do they take those kinds of issues into consideration when they're looking at, even though you may be creating a very concentrated market because only one person is creating this new drug? Do they take that kind of thing into consideration?
I mean, every market is unique. I think we can agree on that. And every market is difficult to define in antitrust terms. When you're talking about drugs, it's very difficult to determine which drugs compete with which other drugs for particular patients. Some drugs might be good for men but not women, and some old people and not young people. Market definition is very, very difficult in any case involving drugs, but it's also difficult for cases involving computers and most things. But yes, every market is different, no question about it.
Okay. Thank you. Any further? No?
I would agree. Every market is different, and want to make sure that that's recognized.
Okay, thank you. Welcome.
Commissioners, thank you very much. My name is Gilbert Lara here on behalf of Biocom California, and we are also a life sciences trade association. We represent biotechnology organizations, research institutions, and universities as well. We did submit public comment through the formal process earlier. So I would like to keep my comments very brief, but point out one thing that was just recently mentioned by the doctor today. A peer-reviewed study by the Cornerstone Research in 2025, published in Concurrence's Law and Economics, analyzed over 33,000 drug projects between 1995 and 2024. The study found that the drugs which undergo mergers and acquisitions are nearly twice as likely to reach patients as non-acquired ones. For novel drugs, which are developed to address unmet medical needs, as mentioned, for different populations and individuals, and recognized as such by the FDA, the likelihood of that product to launch is more than 3 times greater if they were in the mergers and acquisitions situation. I want to appreciate the work that was talked about today. A lot has changed and a lot has been considered, but we urge the Commission to reconsider the proposed frameworks after transmitting any recommendation to the legislature. California's patients, workers, and research institutions deserve a merger standard that reflects the realities of the industry that serves the life sciences industry. Thank you.
Any questions or comments from commissioners? None? Thank you. You're welcome. You just talk. There's no microphone.
I was looking for a mic. I saw that. Hi, everyone. My name is Alejandra Alvarado. I'm here representing Rise Academy, a member-led alliance of over 300 nonprofit organizations throughout the state dedicated to combating the legacy of redlining in communities of color by holding banks accountable to play a positive role in creating community-centered economies. Thank you to the CLRC and its staff for their diligent and in-depth work they've done throughout this process, and we appreciate the Commission's and staff's excellent work on this issue. We stand in strong support of options 2, 3, and 4, and specifically in support of the appreciable risk standard, which is best practice firmly rooted in existing federal law. We believe there are several additional changes that would be strengthened, but I'd like to focus the rest of my comments on consolidation that is being overlooked in the financial service industry. Today, banks are merging at the fastest pace in 35 years, enabled by merger-friendly regulations and weak state and federal laws, which are approving merger deals in record time. Nearly 150 mergers worth around $45 billion have already closed in 2025, with an average approval time of just 4 months. And these deals range from small banks to large regional bank transactions. While the trend is accelerating, this isn't new. This is embedded in the industry's ethos, as evidenced by the tremendous consolidation and concentration of enormous market power. The top 4 banks now hold 30% of the nation's 18.3 trillion in deposits, and top 10 hold about 44%. We know that bank mergers can cause lasting harm, yet the federal and state review process remain tilted towards approval and lack safeguards to protect consumers and communities. The majority of bank mergers are approved even when community groups raise significant concerns about the negative effects. Mergers and this level of consolidation has resulted in communities of color suffering from lost jobs, reduced hours, working conditions in frontline bank branches, closed branches, decreased investment activity, reduced access to credit for small businesses, and risk to our financial system. The more the industry consolidates, the less options consumers have when choosing a bank. This also results in the bank deserts. These banking deserts especially hurt older adults who are more likely to bank in person, a fact that enables banks to detect elder financial exploitation as recognized by the OCC and FDIC since at least 2013. The Federal Reserve Bank of Philadelphia found that between 2019 and 2023, a period of large merger volume, the number of banking deserts across the country increased by 271, leaving over 760,000 more people adequate access to branches. Further consolidation has led banks paying consumers negligible amounts of interest in exchange for the privilege of holding and investing consumers' low-cost deposits. For as long as the modern banking system has existed, it has marginalized low-income communities and people of color. Researchers have found that the decline in institutions and loss in branch locations is related to an increase in the share of underbanked and unbanked populations. Bank consolidation is accelerating existing inequities and weakening communities. Strengthening merger oversight is essential to protect consumers, workers, communities, and especially communities of color. Another troubling merger trend is credit unions acquiring CRA-regulated banks. 10 years ago, credit unions acquired only a handful of small banks annually, but they're now buying institutions worth hundreds of millions of dollars. There have been 2 examples in California in the last couple of years. In one recent case, a credit union with a troubling record of gouging young Marine recruit customers with overdraft fees was able to acquire a community bank that achieved an outstanding community reinvestment rating. While data on the bank mergers impacts communities is limited, existing analysis of branch data and bank consolidation highlight the disturbing patterns. In closing, simply commodifying the same language as federal law, it will not protect against the erosion of those existing best practices. We strongly encourage you to adopt options 2, 3, and 4, including the tried and tested appreciable risk standard. Thank you.
Thank you. Any questions or comments from commission members? Seeing none, thank you. Any other public comment in the room? Seeing none, any? Yes?
Yes.
Online?
Yes.
You got?
All right, we have 8 right now.
8?
Yes.
Okay.
So, Bilal Saeed.
Sure, thank you. I don't have a prepared statement, but I wanted to respond to a few points that Professor Land raised. So first, I'm a counsel at the law firm of Cadwalader. I am a counsel at a public policy group called Tech Freedom, and I also teach as an adjunct at George Mason University's law school for most of the last 15 years, and this semester at Arizona State University's law school. I teach antitrust and only antitrust. First, I want to return to a question that was kicking around at the beginning and that I think Commissioner Carrillo has still outstanding. The standard for finding a violation or the level of proof required is clearly reasonable probability or reasonable likelihood. Notwithstanding a few comments that have suggested maybe the courts are moving to a higher standard of will or is likely, those submissions take the case language out of context. In fact, they misrepresent the language, and I've shared language or written email with Ms. Riley on that point. The standard, it is black letter law that the standard is reasonable probability or reasonable likelihood. I'll turn to Professor Land's other comment, and I respect Professor Land, and I believe he knows that. He mentions then Judge Thomas's opinion in Baker Hughes, which set out a burden shifting framework and suggests that correctly suggests that the court says the ultimate burden of persuasion, the ultimate burden of showing illegality is on the plaintiff. But in the structured framework for working through the analysis, the court generally credits the plaintiff and requires the plaintiff to show, to make out its prima facie case of harm or potential harm or likely harm, probable harm. In a horizontal merger, usually in two ways. First, they accept that the merger will raise concentration or occur in a market that is highly concentrated, and the change in concentration will be of some significance. That is one way the plaintiff can establish its relatively low burden to sort of push the analysis down to the defendant. Plaintiffs also often show close competition between the two firms. The defendant then has the obligation or the requirement or the burden to show not only through production of evidence of evidence that undercuts that presumption, but really it is a burden of persuasion that its arguments are effective. So certain arguments the defendant makes will be the market definition is wrong. Well, the defendant has to show why the plaintiff's market definition is incorrect. The defendant may come forward with efficiency justifications. Well, the burden is on the plaintiff to convince the court that those efficiencies will have the effect of, addressing the competitive harm. The defendant may come forward with evidence with respect to entry, that firms will enter, that entry is easy, right? The burden of convincing the court is on the defendant, right? So they have a burden of persuasion. Now, if the defendant meets its sort of burden of rebutting the presumptive case of the plaintiff, the burden shifts back to the plaintiff to basically show that the harm is greater than the benefit, right? So the ultimate burden of bringing a case is always on the plaintiff. But the intermediate steps, it is not simply a burden of production, but a burden of persuasion. The defendant has significant burdens on them to show evidence that rebuts the prima facie case. I will also comment on this appreciable risk language. Look, I was at the FTC from 2018 to early 2021. We were thinking about these types of questions. I believe, and it's only my belief, others can talk to it, that the attempt to use language such as appreciable risk or risk of harm is an attempt to move away from the federal case law, which is now 100 years old and more, that sets the standard at reasonable probability or reasonable likelihood. The reason I believe there's an attempt to do that, and we thought about it in the first Trump administration, is because reasonable probability or reasonable likelihood looks like something of 50% or more likely than not, right? I believe the attempt to use different language is to get that sort of, quantitative measure down below 50%. That may be good, that may be bad, but I believe that's the reason for the distinction, right? It's a concern that the 50% test or 50% plus one is too high, but people can debate that. I will comment on another commissioner's comment. The case law generally does not take account of the magnitude of expected harm or the magnitude of harm. I think in part because for 60, 70, 80 years, nobody had a good sense of how to evaluate likely, the magnitude of that harm. In the last 25, 30 years, econometric techniques have been developed where the parties, whether it's the government, the plaintiff, or the defendant, do try to quantify, let's say the price effect or the output effect. But those models are subject to error, subject to assumptions. And so I think the courts have not moved in the context of sort of an expected value of harm, probability times magnitude, and have stayed at this sort of, probability calculation or determination. Now, of course, it's absolutely correct that, determining the probability of a future event is a predictive exercise. And nobody is quantifying it at 50% plus one or 55 or 60% or 70%, right? It is an analysis by the court of all the evidence that is put forward. It is going to be hard to get certainty around merger analysis because it usually concerns the effect of the merger over time in the future. It is inherently predictive, right? But the courts have establish the process to get, to make a best case, best analysis, best determination of it. And I think, look, I grew up reading Judge Posner, but Judge Posner has not done a merger since 1986. And he, putting aside his current condition, and I don't mean to make light of it at all, he is not familiar with the way courts and agencies have begun to evaluate efficiency claims. Now, in practice, most courts reject the efficiency claims of defendants for various reasons, but they do take the time, as do the FTC and DOJ, of evaluating those efficiency claims and evaluating them seriously. So there's no reason, I think, to shift the burden of persuasion in the entirety the way Professor Land suggests. The government wins, I'd say, 2/3 or slightly more of its merger cases, right? When the government loses merger cases, they sit down, they think about how to tell stronger stories. So I encourage the commission to think hard about the way merger law has developed, not only over the last 20, 30 years, but the techniques and how it's developed and how the agencies have responded to losses. In the 1980s, the government, in particular the Department of Justice, brought a number of cases that were based on presumptions, right? And their basic story was high market share, high concentration after the merger, and that entry was hard. Well, the appellate courts slapped them down because they told sort of an incomplete story. And the way the Department of Justice responded was, in a sense, putting the burden on itself to tell a competitive effects story that was more than just the market share and entry story. And since then, the government has had substantial success in winning litigated merger challenges. They don't win them all. But I think if you go back 10, 15, 20, 30 years, you'll see it's about a 2/3 win rate. Okay, so, the state may or may not wish to adopt its own law. Personally, I think it's not necessary. Existing Section 7 law is flexible enough, thorough enough, and sophisticated enough to adapt to different markets, changing conditions, and new economic science. So I think the best thing the California legislature can do is give the AG more money, right, to bring cases if it believes the federal government is not bringing the right mix of cases. But the law here is very flexible, very strong, and I think putting in more specificity is probably going to have less of an effect than you think, right? Because these are factual determinations. These are factual determinations. Cases are not won or lost on questions of law. They're won or lost on the court's analysis facts. So thank you. And thank you for letting me go on a little bit longer than usual.
Thank you. That's very helpful. I think Professor Land has his hand raised.
Am I still unmuted?
Yes.
Okay, great. I agree with much of what Professor Said said, much of it, but I would like to make 3 comments. First, the power of judges is immense. An ultra-conservative judge like Clarence Thomas will rule differently. His opinion was kind of overruled by the next opinion in the DC Circuit by Judge Merrick Garland. So yes, the judge makes an incredible difference when they look at the facts. They look at the facts as resulting in competition, or they look at the facts resulting in uncompetitive. Absolutely, that's very true. A lot of us believe that too many mergers have gotten through. Maybe the government stops a bunch of them, but then we've seen the evidence presented in other hearings that too many mergers have gotten through and have led to higher prices and bad effects on workers and bad effects on competition and so on. The only thing I'd like to point out is the original formulation of Philadelphia National Bank had the word clearly in it. That is, there's a structural presumption unless defendant clearly shows that there's not a problem due to ease of entry or something. And then subsequent court decisions have left the word clearly out. Now, that's an amazing signal to the judge. If you would reinforce the word clearly, that is, there's a Philadelphia National Bank presumption or a presumption, unless defendant can clearly show that the presumption is not warranted due to something like ease of entry. That'll be a signal to the judges, assuming the judges want to follow the statute in good faith. That's a signal that the rebuttal should be taken seriously, and defendants must clearly show, for example, ease of entry.
Thank you. Any other questions or comments from commissioners? In terms of maybe for the 2 of you, we've been sort of toying around with language like that we have in subdivision C, a merger that may produce a firm controlling an undue percentage. We have where the effect subject to position may be to substantially lessen competition. How does, in terms of the percentage, the likelihood, the percentage of likely bad outcome, is that, how does that compare to if you were to say that this merger or acquisition is more likely than not to lessen competition? Is that, I mean, more likely than not, I think of as, 51%.
Right.
How does some of the other language compare to more likely than not?
I prefer the formulation, it may lessen competition.
Okay,
may substantially, may tend to create a monopoly. May, to me, sounds less than a 50%, and okay. I believe that's appropriate.
And that should be part of the burden shift.
Excuse me?
Part of the burden shift?
Yes, certainly.
Okay. And I think our speaker wanted to respond as well.
Well, look, I think a standard much lower than 50% is probably the wrong standard, and it does shift, it does shift the burden, I think, in an unequal way. The language of the Clayton Act is already whose effect may be substantially to lessen competition, and the courts over the 110, 12 years have interpreted may be substantially to mean reasonable probability, right? So while I think there is some merit to what the courts have done for over 100 years. If you want to lower the standard below whatever 50%, and of course you recognize nobody actually measures the probability.
Right.
It's more likely than not, as opposed to beyond a reasonable doubt or something, right? You probably have to say it directly, right? You probably have to say specifically something less than 50%, but hopefully more than a de minimis amount, right? I mean, there are benefits to mergers, and language that makes them significantly harder to do is going to hurt firms and potentially economies. I will say one more thing about, I'd like to say one thing about Philadelphia National Bank. Bob is correct that the market share of the firms there, the combined market share, was in the range of 35, 36%. The other thing I think that is important to recognize about this question of undue share in that case was that combination would have made them by far the largest firm in the market, right? And so, again, as we thought about this question when I was in the government, and as I think about it when I teach, it ought to matter if the firm is the largest or not the largest in the market, right? Combined with that share. So if you were to say like a 30% share triggers this sort of presumption or burden, it is possible that that firm would still be only the third largest firm in the market, right? And if you have a market where you have firms in the range of 30 to 40%, let's say the first or the number one, the number two firm are at 40 and 30%, you may not want to block a merger that creates a third player of similar size, right? Because it may make them more competitive. It may be that somehow the market is changing and that firms have to be larger. So if you are going to include some type of undue percentage, whether it's a number or a concept, I think you want to also include a reference to and is or would be the largest firm in the market, so that you don't unnecessarily penalize firms for attempting to grow through merger, where that merger may make them stronger competitors to other firms in the market, whether it's locally or nationally or internationally, right? And the courts, while the courts, what the courts have done with the PMB presumption is not ignore it, but recognize that the strength of the presumption that is created by a certain market share or a concentration may in fact be dependent on the level of the market share and the level of concentration or the degree of change, right? So 35% doesn't get the same, the strength of a presumption around a 35% share is not the same as the strength of a presumption around a 70 or 80% share, right? It's a very good opinion by Doug Ginsburg from 2001 in the DC Circuit about the merger of baby food manufacturing companies. He says, look, we have never allowed, or we are very careful about allowing a merger from 3 to 2 firms, right? A duopoly. A lot of, we're very concerned about those transactions. Those types of transactions are different than a 5 to 4 or even a 4 to 3. So the difficulty with these hard numbers in the statute is that they can become, anchors as opposed to instructive. And the case law has been very good about not anchoring itself, but considering, the factual circumstances of the industry, the players, considering the forward-looking effect, right? Right? Firms may be strong today, their market shares are based on past performance, but there may be some weakness in those in the forward or predictive level of those statistics. So, I think I merger law is pretty sophisticated, and it has developed the last 20, 25, 30 years in a way much different than many of us are sort of familiar with from our time in law school. And I think if you don't have a clear understanding of that, you do get hung up on these numbers. And it's just not the way merger law is practiced today. So, conceptually, if I were trying to build in something in a statute, I would build in something like, this Baker Hughes framework of, or look, I wouldn't even put it in a statute. I may put it in the notes, but the plaintiff has sort of an initial burden, the defendant that has the burden of rebutting that, with evidence, right? And make clear that the defendant has sort of an intermediate persuasive burden. And then again, the plaintiff, the court has to evaluate the full totality of the evidence, right? I mean, you don't want courts taking shortcuts either on behalf of the plaintiff or on the defendant. And you saw that type, sometimes they take shortcuts on behalf of the plaintiff. Sometimes they do it on behalf of the defendant. You want to avoid that. You want this sort of full competitive effects analysis that, the guidelines since the 92 horizontal merger guidelines incorporate to different degrees. I don't like a lot of what's in the 2023 merger guidelines as opposed to earlier iterations, but they do maintain this idea of a holistic analysis and avoid litigating cases by pointing to one number, right? The guidelines adopted that 1800 number. It is a falsehood that they looked back at old cases and decided that was the proper number. It was a choice. They can make that choice. But what you haven't seen is, and I'll say the Biden administration and the first year or so of the Trump administration, you don't see them litigating cases at 1800 concentration level because they are very hard to show harm at that level if that is the only rationale, right?
Thank you. Thank you. That's very helpful.
Thank you.
Yeah, I know we have some other folks who want to make presentations. I'd like to be able to get to them as well. So thank you, sir. Christy?
Kindernath Sin Carmen.
Okay.
Hi, can everyone hear me?
Yes.
Okay, just give me 1 second. Good afternoon, Chairperson and members of the Commission. Thank you for this opportunity to comment. My name is Kedarnath Sankararaman. I represent the Association for Competitive Technology, or ACT. We are a global trade association representing small business software application developers and connected device companies that drive the global app economy. We are here today to express deep concerns with the revised draft language options presented in Memorandum 2026-14. While we strongly support effective competition enforcement, we oppose any California-specific merger standard that departs from well-established norms that allow pro-competitive tech mergers. Crucially, even for firms not looking for an acquisition, closing down their acquisition prospects affects their enterprise value. Why does this matter? Because it affects their ability to negotiate with potential investors. They have leverage if investors know they have value in the market. For startups that are on the market, acquisition is not a failure of competition. It is often the most realistic and pro-consumer path to success. Initial public offerings are costly and inaccessible to most small firms. Consider a hypothetical. A small startup develops a novel AI algorithm that drastically improves medical imaging diagnostics, but they lack the massive server infrastructure, the regulatory compliance teams, and the distribution networks to get it into hospitals. Being acquired by a larger health tech company allows that life-saving technology to reach scale quickly and, more importantly, to benefit patients. Yet, under the strict structural presumptions proposed in options 2 and 3, this acquisition could be presumed illegal simply because the acquiring company holds a significant market share in health software. And the strict rebuttal standard in option 3 would improperly marginalize the massive efficiencies of this deal. It requires merging parties to prove the pro-competitive benefits occur in the exact same relevant markets as the alleged harm, and only considers efficiencies if the anti-competitive effects are de minimis. Small app developers like ACT members and connected devices companies rarely build products that fit neatly into a single market. Their innovations touch multiple markets simultaneously. A rebuttal standard that only counts benefits in one narrow market while ignoring transformative benefits everywhere else punishes exactly the kind of cross-market innovation our members specialize in. This is especially critical in the AI era. AI development requires immense computational resources and capital. The next generation of AI innovation will come from startups partnering with or being acquired by larger firms that can provide that infrastructure. If California makes these acquisitions presumptively illegal based on rigid structural shortcuts, we will choke off the very ecosystem that makes California the global leader in AI. Option 4 is especially troubling. Its appreciable risk standard is novel and untested. That kind of uncertainty chills the very exit opportunities that drive early stage investment and startup formation in California. Finally, the proposed purpose statement, which invites courts to disregard federal case law, would sever California from decades of precedent that provides predictability to the market. We urge the Commission to reject these divergent standards and continue relying on established federal legal framework, which already empowers the California Attorney General to independently challenge anti-competitive mergers. Thank you very much for your time. We would be happy to follow up and present a written statement for the record.
Thank you. Are there any questions or comments from commissioners? Seeing none, thank you so much. Next.
Professor Robin Feldman.
Okay.
Thank you very much. I appreciate the opportunity to speak today, and I'm going to focus on addressing an issue that was raised in some of the public comments, not the ones here necessarily, but the ones that were submitted, concerning whether the proposed amendments that you all are considering will chill innovation in biotechnology. I wanted to comment on that because I do believe that concern is misplaced. In fact, I think we face the opposite problem right now in the pharmaceutical industry. The steady drumbeat of consolidation in that industry is having a negative effect on innovation, and one that's been measured by scholars in a number of settings. I'll go through some of that research in a minute, but measures that allow competition to flourish, like the ones you're considering, if they are carefully and thoughtfully applied, have the potential to reinvigorate the biotechnology industry, and that has been one of California's crown jewels. I recently collaborated with scholars at Berkeley and at UCLA to study consolidation in pharmaceutical markets. And to put it simply, we found that the waves of consolidation in the pharmaceutical industry have consistently reduced innovation. So specifically, in recent decades, 3 waves of mergers have substantially increased concentration in the pharmaceutical industry. And we've seen a dramatically consolidated industry. So in 1987, the combined market share of the 8 largest drug companies stood at a relatively low 36%. By 2012, in the wake of the second merger wave, that combined market share of the 8 largest companies had climbed to 53%. And all told, between 1995 and 2015, the 60 leading pharmaceutical companies merged to only 10. That's a significant shrinkage. As I noted, consolidation is not necessarily concerning if competition remains brisk and innovation flourishes, but that's not what we've seen across this period. Following the merger waves between the mid-1990s and 2010, we saw a sharp decline in innovation. There was a clear drop-off in new molecular entities, that is, new drugs, and a sharp drop-off in new drug approval rates following those first two waves of consolidation. So we saw massive consolidation, and we saw a sharp decline in innovation that's so essential for the industry. So I think that type of concern is why regulators need tools to address further consolidation when that consolidation threatens to further restrict competition and douse innovation. As everyone knows, today's innovation doesn't happen to big pharma houses. The vast majority happens outside the companies, in academic institutions, in startups, in small companies. That accounts for roughly 75% of pharma innovation. Smaller entities invent, and then they try to sell to the big pharma houses. What I'm about to say here is really key to what this debate is all about. When startups have fewer and fewer options for companies who would buy their drug, that's bad for the startup industry. So anyone who would suggest that startups flourish better when pharma consolidates is, I believe, leaving out a key piece of the picture. I want to close by turning briefly to the proposed language that would codify the HHI index into California law and to some of the conversation that's been going on today. So I note that the HHI proposal creates only a presumption. I believe if you are going to put the HHI language in codified, that flexibility is important. HHI has been an important benchmark in federal judicial and regulatory law, not statute. For some time, it's not always a perfect measure. It can both overstate and it can understate the potential competitive impact of a merger, and particularly for pharmaceutical markets, which are difficult to capture. So I would just caution against adopting any rigid approach to analyzing potential mergers. In that context, I'd like to make a couple of high-level comments about the conversation I've heard today. In terms of the four options in the staff memo that were referred to, I do have concerns about option 4. I have concerns about language that is new and that does not have a history within judicial interpretation that we can understand. I've heard some discussion listening to people about, will a court think this means more or less or 50%, and that's the problem. It's difficult to know where things will go, and there's a potential for, I think, extraordinary mischief if we head off with language that isn't, that doesn't have the benefit of that track record. I think we do have language that has been around a long time. We have Clayton Act language. We have language from Philadelphia National Bank that's been there since 1963. The concern that's been expressed here and in other places is that modern courts have drifted from Philadelphia Bank language and that that's a problem. California has the ability to handle that simply by saying that the California statute, let me put it this way, that federal case law interpreting the federal Clayton Act is persuasive, but not binding on the courts of California insofar as they're interpreting similar language adopted into state law. In other words, I'm saying you can do option 2 that you have here. You can take that language, but you can also put in that for California courts, these federal court interpretations aren't binding on us. May be persuasive, but they're not binding, and that gives California the ability to say, now we're going to stick with the original language. And it also protects against the possibility that the Supreme Court says, we don't like Philadelphia Bank. It gives you that language to run with. So I think you can use that basis. The last thing I would encourage drafters here is that, again, I heard some discussion at different times of people saying, well, by changing this language, we mean to loosen that standard, or we mean to go to the 50% or more. I would just encourage you that if that's what you mean, please say it. So, rather than guessing what the courts will do, referencing what's out there. And if you have an indication saying that clearly, I think we'll get both the state and the courts a lot closer to what you may want. I thank you for the opportunity to speak today.
Thank you very much. Any questions or comments from commissioners? Seeing none, thank you. Next presenter.
Kathleen Foote.
Okay, am I unmuted?
Yes, you are.
Okay,
Welcome.
thank you very much. I am now retired, but was in government, as so many people who've been speaking to you say, different government. I was the chief of the California Attorney General's section of antitrust law for the last 20 years of my career. And so oversaw in that capacity merger investigations, probably 5 or 6 per year that office did. I was also a member of your working group early in the task that you are finalizing here, and as part of working group number 6, which had to do with enforcement. My purpose really in speaking to you today is just to underscore the importance of taking action on the merger front as well as the others that you've been looking at. The economic analysis and enforcement decisions of California and the federal agencies in the vast majority of cases over the years have been aligned and will probably continue to be aligned, but occasionally differ. Those differences, along with a fairly steady decrease in overall federal enforcement over the years, a decrease, relatively speaking, in budget for that at the federal level, really underscore the fact that California can't fully rely on the federal agencies to protect competition adequately in California's enormous economy. Having our own law in our own courts with review and interpretation by the California Supreme Court on a subject that is so fundamental to the success of California's robust economy seems like reason enough for a favorable recommendation here. The cases would still be relatively few coming out of the AG's office. They would also be big and with economic analysis playing a major role. In my experience, under quite a number of state AGs, when the AG has made the decision to challenge a merger in court, it's when there are very significant California-specific impacts on consumers and in markets of major economic and importance and policy importance to California. There's at least one additional reason. Our experience in federal court, in addition to the difficulties antitrust plaintiffs always face due to the long erosion of standards justifying relief, is that the scenario when we are on our own, when our federal enforcement counterparts are absent, presents another obstacle to our success. Our reception there is not at all the same as the reception that the federal agencies receive. And when there has been non-action or insufficient action on the part of the federal enforcer, it is thrown in our face, raised repeatedly by the merging parties in front of the court as if it were somehow or other evidence of a lack of merit of the AG's case. And thus the AG has to overcome yet another evidentiary hurdle. Even more troubling in the last such major case, where we went on our own with several other states, the merger of T-Mobile and Sprint, the U.S. Department of Justice actively fought against the state's right to be there in some quite unprecedented court filings. And whether it was in deference or for some other unstated reason, that particular judge in his memorandum opinion after trial, despite explicitly finding that the states had met their burden of proof with regard to the anti-competitive effects anticipated in key local markets, still declined to block the merger. And California's consumers have been paying the price ever since then. So adding merger authority to the Cartwright Act is important. It's greatly needed reform. It need not, and I suspect would not, prevent state-federal cooperation and joint investigations from going forward under the recently passed sort of mini HSR statute. And even in the very rare instances where a merger might be challenged in two separate courts, as happened in the Kroger-Albertsons merger challenge in Washington State. State and federal courts in California certainly are well equipped to coordinate the pretrial phases and avoid needless duplication and burden on the parties. They've done that often in parallel antitrust cases, state, federal, in the non-merger arena for a very long time. And there's no reason, therefore, every reason they would continue to do that here. I appreciate that the language being considered here in all the various options is in the same sort of spirit and consistency of purpose of your recommendations regarding single firm conduct, and hope that it is presented to the legislature very much in that way, that the law's intent should maintain essentially the deeper and broader aspect, recognizing a very long tradition and a tradition very favorable to competition in California in those areas. And if not so much the emphasis on deterrence that's articulated in those, certainly an emphasis on discouraging bad outcomes, I guess I would say. The clarification that federal law should be informative but not binding precedent. And then the provisions, including avoiding unreasonable burdens of proof with regard shifting the burden in that respect. I would very much like to put in a plug for that as an enforcer. It is, there's the option 3. I think Professor Land's formulation, which you were looking at just before and after the lunch break, looks pretty good to me. And I agree with the comments already made that with a presumption and then a burden shift going forward. Those are by no means new concepts. And they offer guidance, very useful guidance to the business community, which will in effect keep some stuff out of court and not burdening the courts. And they are also useful tools for the courts that the courts already pretty much know how to use. So that certainly would be a consideration in addition to the exact language that you've been considering, which is sort of beyond, as an enforcer, that's a little bit beyond my area. I want to thank you very much, not just for the work that you're doing today, but for the last couple of years of extraordinary effort in a very turbulent time for antitrust. Thank you.
Thank you. Are there questions or comments for this presenter? I just had one. And it kind of also goes back to single firm. If I recall correctly, in single firm litigation, a lot of those end up in federal court because they're class action actions. Is that likely to be the case with mergers and acquisitions, or is that going to be the kind of thing where it'll likely stay in state court because it's the AG that is bringing the?
I think if the state AG brings the case and nobody else is in the case, I mean, no other plaintiffs are in the case, then yes, it will stay in state court. To some extent, that gives the AG and the courts a remarkable opportunity to formulate, to sort of put some English on the law in the relatively near term, if it makes it through the legislature. But with those other cases, if there are, it's very difficult for the AG, given the personnel requirement, given the financial requirement for outside experts, sometimes outside counsel. It's an enormous burden to bring a case like that alone, and it's very important to have partners. The partners in merger cases generally are either the federal enforcement agencies or other states or both. And whenever that is the case, it would have to be in federal court because the rest of them cannot represent their own constituents in California court and under California law by and large. So even if there are state claims being made, they have to go to federal court. And class actions, the same thing, if there were class action. That doesn't mean the federal court can't consider California law. The federal court can and does in those non-merger cases. And to have clear California law and legislative guidance is enormously important because so often California law has been just sort of cavalierly swept under the rug as being just like federal law. And I think I'm sure it's been a steady refrain for you for the last 2 years, that is something that it is important to take steps to avoid in the areas where California law is intended to be different.
So if someone brings an action, if the AG brings an action based on federal law that looks like, one of these three options.
That goes to federal court.
That goes to federal court.
Yeah.
Huh. And is the federal court bound by state law?
Yes. If the federal court is making decisions about state law, the federal court needs to look there are a few distinctions in the class action situation. That's procedure rather than substantive law, or at least there are some arguments about whether it's procedural or substantive. But generally, if it's procedural, federal law will prevail. And that's what they'll use. But if it's substantive, they are constrained to interpret state law, and in some cases, they will make a referral to the state Supreme Court. And in some cases, the AG has, not so very long ago, in quite an important case involving not the antitrust law, but the consumer protection law, asked the Ninth Circuit to, if they were going to sort of step out in any kind of a novel interpretation of California law, that they consider referring it to the California Supreme Court for guidance.
Okay. Thank you. Any questions or comments? Hearing none, thank you so much. Next presenter?
Eric Ensign.
Okay, Eric?
Good afternoon, commissioners. Can you hear me all right?
Yes.
Wonderful. Thank you. This is Eric Ensign with Crowell & Mooring on behalf of the California Chamber of Commerce. Thank you for providing me with some time today. I think it's evident from today's discussions that these issues are incredibly complex, and I think the Commission's work has been made a bit harder by the fact that it's not entirely clear what we are solving for with respect to mergers and acquisitions. Certainly it has been suggested by some that we just need to make it easier to challenge mergers in California as compared to the federal process. I just don't think that's the right goal. Everyone who's talked today, and I think spoken on mergers generally, has agreed that the vast majority of mergers don't create competitive concerns and are good for consumers. So my view is we shouldn't focus on just making challenges easier. We should zero in on a process that may assist in identifying those few transactions that might actually be problematic. If we don't, then we risk tying up and discouraging the many mergers that actually help consumers and foster competition. So to put it another way, let's figure out what the real issue is and work towards solving it. To do that, I think it'd be incredibly helpful if staff or others could identify a few of the mergers that they believe were wrongly handled, either because they weren't challenged or the challenges failed. I heard Ms. Foote refer to T-Mobile Sprint. I think that's helpful. If there are others, I think it'd be helpful to hear about those. If we have those matters, we should be able to evaluate how those mergers would be considered under these options and whether I think it would give the commission more context for the claim problem and possible fixes. I think doing the work in the vacuum is just more difficult. Which leads into my next point, which is whether there is a mergers and acquisitions problem so large that it requires California to set up its own full-blown merger review regime. If California wanted to fully replicate what the federal government's doing, we'd have to dramatically ramp up funding and staffing, of course. The current approach, I think, is incredibly practical. The Attorney General weighs in and challenges the small number of potentially concerning mergers when necessary. Just this week, the California Attorney General and other states sued here in California federal court to block the Nexstar Tegna Broadcasting merger. And they did it without the support of the federal government. They are going it alone on that one. And so, as we've said before, California clearly has an important role in merger enforcement, and the current system allows the state to reserve resources, but also act when it's in California's interests. In terms of substance, we will be weighing in with a written public comment after we've had more time to review the options in the memo and what's discussed today. But in general, the options all build off each other. And by the time you get to the fourth option, there are several different standards that courts could use to decide if a merger is good or bad. But look, our view is the more legal tests you have, the more confusion and uncertainty you create for courts and businesses. We would like a standard that is narrow, clearly defined, and concise so everyone knows what to expect. And following up on your question earlier, Commissioner Simpson, about consideration of individual markets, and Professor Saeed addressed this somewhat, our concerns with basing merger decisions on presumptions, whether it's Philadelphia National Bank or HHI, is that, the merger analysis is not in-depth enough, in fact, intensive enough to really explore whether or not the merger is going to injure competition or not. So we will comment on presumptions and get you our thoughts on that. Finally, I know the commission is being deliberate with this process, of course, but I wanted to urge, maybe give a plug for giving this a little more time, given all that is going on in Sacramento with respect to antitrust. As you know, last year, California took 3 concrete steps on the antitrust front. Cartwright Act fines were increased. Collusion through pricing algorithms was expressly outlawed. And California enacted SB 25, giving the state robust pre-merger reporting process. As I'm sure you know, the legislature now has before it 3 bills aimed at amending the Cartwright Act, including one that is similar to proposals the commission rejected, and then of course AB 1776 based on the commission's recommendation. I think we will learn quite a bit as these developments set in and as the legislature deals with the pending Cartwright Act bills, and it could inform how what the commission wants to do with respect to mergers and acquisitions. So we think taking the time to let all of that play out could be a good opportunity for all of us. With that, I thank you for the time, and I'm happy to answer any questions you might have.
Well, since we don't have a quorum to take a vote today, we'll give you a little more time. Any questions or comments from commissioners? Hearing none. Thank you so much. Next.
Bianca Blomquist.
Okay.
Hey there. I'm assuming you can hear me okay. Good
Yes.
afternoon. Thank you, Chairperson Simpson. I appreciate it. Vice Chair King and Commissioners. My name is Bianca Blomquist, and I'm speaking on behalf of Small Business Majority, We are a national education, research, and small business advocacy organization founded by small business owners in 2005. Our mission is to ensure diverse business owners can contribute meaningfully to our economy. 99% of all businesses are small, and they employ roughly half of California's private sector workforce. This means that any merger of or acquiring of small businesses do materially impact and can materially impact the workers, the small business owners hire, and the local communities that these small business owners serve. In fact, 97% of those small businesses are very small businesses. As a representative of 4.3 million California small business owners, I see firsthand how mergers have replaced organic growth with acquisitions that prioritize shareholder profits, especially over small business needs. In California, our state's concentration crisis is no secret. We have some of the worst levels of inequality in the country, and it's time for us to take action. For several years, I followed and participated in the California Law Review Commission studies, including bringing various small business owners directly to this distinguished table. Today, I'm here to talk about why we stand in strong support of options 2, 3, and 4, including the appreciable risk standard. Tuttle's Pharmacy in Santa Rosa was an 84-year-old family-owned business that had served the North Bay for generations before being acquired by the national chain Rite Aid. Following the acquisition, the local Tuttle's locations were closed. Customers were redirected to nearby chain pharmacies. For many in my community, which is Sebastopol, it marked the loss of a trusted independent provider, replaced by a larger corporate presence, and highlighted the growing challenges small, locally owned businesses face as consolidation increases across all of our main streets. Preventing anti-competitive mergers isn't just about protecting consumers, it's enabling honest businesses like ours to innovate and compete for dedicated workers. That's a fundamentally pro-business reform that creates a level playing field. According to our research, 75% of small business owners support stronger government authority to block mergers and acquisitions in heavily consolidated industries like healthcare. In healthcare, since 1998, there have been over 2,000 hospital and health system mergers. Private equity acquisitions in healthcare increased more than sixfold between 2012 and 2021. This impacts small business owners. Half of all ACA enrollees are small business owners or work for one. Options 2, 3, and 4 would enshrine best practices firmly rooted in existing federal law, including the appreciable risk standard. This isn't new. It's based on century-old principles of under federal law. We urge you to adopt these standards and create these real protections for California's small business owners. Thank you. Happy Friday.
Thank you. Looking forward to a happy weekend. Thank you so much. Any questions or comments for this presenter? Seeing none. Thank you. Next.
Tasia Stevens.
And how many more after that?
7.
7?
Good
Okay.
afternoon. Oh, sorry. Good afternoon, Honorable Chairperson Simpson and Commissioners. My name is Tasia Stevens. I'm speaking on behalf of the United Domestic Workers AFSCME Local 3930 and our 225,000 IHSS and family childcare workers across the state of California. For the past several years, UDW joined the Anti-Monopoly Coalition, which includes labor and consumer advocates, business leaders, and antitrust experts to follow along with the study. As members of the coalition, we stand in strong support of options 2, 3, and 4, and specifically in support of the appreciable risk standard. Our workers are the backbone of California's care economy. They help seniors remain in their homes with dignity, support people with disabilities, and educate children so parents can work knowing their kids are safe, supported, and nurtured. Despite the essential care our workers provide, which contributes to California being the 4th largest economy in the world, everyday Californians like our providers are struggling with the impacts of the concentration crisis and the increasing levels of inequality across the country. As a union primarily made up of people of color, we know that economic effects of concentrated corporate power have disproportionate consequences for workers in communities of color, exacerbating inequalities caused by racial exclusion and other forms of extraordinary systemic discrimination. Mergers have replaced organic growth through positive innovation that benefits consumers and workers, and instead led with a pattern of acquisitions that have resulted in greater shareholder profits at the expense of layoffs, decreased union power to negotiate better wages and working conditions, which our union does, higher prices, and fewer opportunities for small businesses. Mergers reform fills a severe gap in California, and we cannot currently We do not currently have a law that explicitly allows mergers to be challenged in our state court, which places all the folks that I just mentioned at a further disadvantage. This is why, again, we are strongly supporting options 2, 3, and 4, including the appreciable risk. At a minimum, Californians deserve the best practices available to be codified so that illegal mergers can be challenged in California courts and we can begin addressing this crisis we find ourselves in. I just want to thank you all for your time and your consideration.
Thank you very much. Any questions or comments for this presenter? Seeing none, thank you. Next presenter, please.
Devin Gray.
Good afternoon, everyone. Really appreciate the time. I'll be brief. My name is Devin Gray. I serve as president of End Poverty in California. We're an advocacy and storytelling organization that travels the state convening Californians living in poverty to better understand their challenges with the economy and, importantly, elevate their solutions for statewide action. For the past year or so, I've followed along with the CLRC study, and I'm proud to be part of the Anti-Monopoly Coalition that you've heard from en masse today. We'd just like to affirm our strong support, again, for options 2, 3, and 4, with a particular support for the appreciable risk standard. We know that California has, over the last many years, earned the distinction of having the highest poverty rate in the country when accounting for cost of living, along with a significant racial wealth gap, which nationally remains as wide today as it was when the Civil Rights Act of 1964 was passed. And when we travel across the state and hear directly from low-income Californians, particularly those in communities of color, people really do intuit that the consolidation of key markets has contributed to harm both for consumers and small business owners through things like increased prices and higher barriers to entry for incumbent actors in a given industry.
Now there's commentary.
That? Oh. What happened?
Still there?
Still there?
Did I cut out there?
Oh, okay. Okay.
Sorry, I hope you got most of that. I do want to impress upon you all, though, that when we see increased prices and depressed wages, these are things that are borne disproportionately by low-income Californians of color, and that creating barriers to entry for small business ownership makes one of the tried and true methods for lifting people of color out of poverty less available. So at a time when affordability and wealth inequality remain defining issues, both for California and the nation, we have an opportunity here to begin course correction. And merely codifying the same language as federal law will not do this. And as such, we again strongly encourage the adoptions of options 2, 3, and 4, again, including the appreciable risk standard. Thank you.
Thank you. Any questions or comments for this presenter? Seeing none, thank you. Next.
Daniela Fernandez Yulin.
Okay.
Good afternoon. My name is Daniela Fernandez Yulin, and I'm speaking on behalf of Cameo Network, a national coalition of community-based small business organizations committed to advancing equitable access to capital, fair markets, and economic opportunity for California's smallest businesses, especially entrepreneurs of color, women, immigrants, and low-wealth communities. For the past several months, I, along with my organization, have followed along with the California Law Revisions Commission study and joined the Anti-Monopoly Coalition, which includes labor and consumer advocates, business leaders, and antitrust experts. We stand in strong support of options 2, 3, and 4, and specifically in support of the appreciable risk standard, which is a best practice firmly rooted in existing federal law. California's economy is incredibly strong, but too many small businesses are getting squeezed out. While our state leads the nation in productivity, it also faces some of the highest levels of inequality. Instead of growing through innovation and new ideas, we're seeing more large corporations expand by buying up competitors. That often means fewer opportunities for small businesses to start, grow, and compete. For small business advocates, this isn't just about prices or wages, it's about fairness. When a handful of big players control the market, it becomes harder for local entrepreneurs to get a foothold, bring new ideas to life, and serve their communities. Keeping markets competitive helps ensure that small businesses have a real chance to succeed and that success is driven by hard work and innovation and not just size and power. We strongly support staff's recommendations in options 2, 3, and 4. These proposals are nothing new and represent best practices that are firmly rooted in century-old legal doctrine. Options 2, 3, and 4 will enshrine these long-standing best practices in California state law. In particular, we urge you to support the appreciable risk standard in option 4. The appreciable risk standard codifies the intent of Congress when it passed the Federal Clean Act in 1914, when it stated the mergers must be stopped before a concentration crisis occurs, when they may tend to create a monopoly. At the very least, Californians deserve strong, clear rules that make it possible to challenge harmful mergers in our state courts. Small business owners need those protections in place so that they can stand up to unfair competition and have a real shot at staying in business and growing. In conclusion, merely codifying the same exact language as federal law will not protect against the erosion of those existing best practices. We strongly encourage you to adopt options 2, 3, and 4, including the tried and tested appreciable risk standard. Thank you for your time.
Thank you. Is there any question or comment for this presenter? Seeing none, thank you very much. Next.
Robert Hurrell.
Good afternoon. I assume you all can hear me okay.
Yes.
My name is Robert Hurrell. I'm the Executive Director of the Consumer Federation of California. We have a long, active flow of consumer protection and consumer rights work that includes the legislature and at departments and regulatory agencies and beyond. I'll be brief. I want to thank Chair Simpson, Vice Chair King, all the members of the commission. I know, and particularly the staff who I know has done yeoman's work over the past 2-3 years on a wide range of very tricky and complicated issues, and done a really wonderful job. We are active members of the Anti-Monopoly Coalition. We support options 2, 3, and 4, including the appreciable risk standard. Because you've heard quite a bit about that already, I won't go into more detail. I also won't go into the level of detail that Professor Saeed did, though I appreciated the educational component of his back and forth with Professor Foote and others. I would note that I am swayed by this notion that federal decisions are informative or persuasive, I heard both, but not binding precedent. I think that's really what is before you today. And if I could just close by using a real-world example. The merger between Live Nation and Ticketmaster, which was, in fairness, approved under the Obama administration more than a decade ago, has wreaked havoc on consumers and created an almost unstoppable monopoly. This led to a series of consent decrees where the merged entities theoretically agreed to change their behavior or limit it in certain ways so as to not be anti-competitive. No sooner was the ink dry on those respective consent decrees, and it's plural because there were multiple consent decrees, they were violated as a common matter of business practice once the entities were allowed to merge. That is unacceptable. And what have we seen lately? We've saw the head of the federal DOJ antitrust unit essentially asked to leave. And instead, there is a proposal for a settlement, which of the 39 states plus DC that are part of that lawsuit, including California, I believe the number is that 36 of those 39 have rejected that settlement. And instead, those states, including California, wish to move forward. So that says to me that as a practical matter, and I say this with all due respect to the wonderful people at the federal DOJ who are still trying to do their jobs under very trying circumstances, the current federal merger policy appears to be what I refer to as the dear leader policy, which is to say, you get your merger if dear leader shines upon you and thinks that it is okay. That is totally unacceptable. It is all the more reason why California ought to be clear that we, in some cases, need to take matters into our own hands, file some of these cases in state court with the tools that the AG and their office needs. And you heard that from Ms. Foote, who ran their antitrust division for a couple of decades. With that, I thank you all very much for your time and for hearing these multiple comments. I apologize for your lack of a quorum, Chair Simpson. I'm sure you'll get one at the next meeting, and I wish you all a good weekend. Thank you.
Thank you, Robert. Any questions? No. Next.
Mona Masri.
Okay.
Hello, can you hear me?
Yes, we can.
Great. Yes, thank you. So my name is Mona Masri. I'm representing Economic Security California Action today. And I want to start by thanking the chair and the commissioners and especially the staff for your continued outstanding, thorough, and transparent work on this and all the issues that have been a part of this study. We've been following along with this study with our Anti-Monopoly Coalition, many of whom have spoken here today and at previous meetings, which includes folks from labor, consumer advocates, business leaders, and antitrust experts. I just want to say, without repeating too many things, but the promise and the vision of a fair and competitive California is one where workers take home wages that reflect their labor, small businesses are able to compete fairly, and consumers pay prices set by markets rather than monopolies. But with federal antitrust enforcement being eroded in front of our eyes and corporate power consolidation at historic rates, our state, the world's largest fourth economy now, can no longer afford to outsource merger oversight to Washington, as you've heard today from many individuals. Maintaining a strong and competitive economy depends on California having the legal tools to enforce that vision within, our own borders. And we've seen how our Attorney General has been active in opposing potential anti-competitive deals. In fact, just a couple of days ago, we saw the Attorney General file suit to block a behemoth broadcast merger between Nexstar and Tegna, which would give one company control over 265 TV stations. And that merger, we saw it being waved through by the current administration. And California, so that and other similar cases are exactly the kinds of mergers that a strong California merger law could address. But right now, our state has no law that explicitly allows mergers to be challenged in state court, again, as we've heard, placing Californians at serious disadvantage. And although our Attorney General is stepping up to protect Californians against this compromised administration, he can only do so in federal court. So we must give our state the tools to effectively act in our state as well. So we strongly encourage you to adopt, as many speakers before me have said, options 2, 3, and 4, and especially the tried and true tested appreciable risk standard. Adopting these options would enshrine these long-standing best practices in our California state law and give the state the tools it needs to prevent anti-competitive acquisitions that while strengthening the enforceability and predictability of the law for small businesses, workers, and consumers across our state. Thank you very much again for your continued and outstanding work.
Thank you very much. Any questions or comments for this presenter? Seeing none. Thank you. And next we have
Lee Hepner.
Lee Hepner. Welcome back.
Thank you so much, commissioners, and good afternoon. I'm Lee Hepner from the American Economic Liberties Project, and I'm a member of this broader anti-monopoly coalition that has been growing and joining these meetings for several years now. We do stand on the shoulders of giants. I want to thank Mr. Land, Mr. Syed, Ms. Foote, and Ms. Feldman for their comments. It's quite an education. I want to associate myself with the comments of Professor Feldman about the life sciences industry. I thought that was astute. She was, in fact, my 1L law professor, law school professor, and gave me an A in that class. So I owe her a couple of thanks over the years.
Yeah.
I also want to seize on Mr. Land's comments to the effect that the staff recommendations are not creating new standards, but really codifying best practices to prevent further erosion by the federal courts. He spoke to the fact that despite what the law has said for a century, sometimes judges get it wrong. And that is certainly happening, and that is absolutely correct. I believe options 2, 3, and 4 are all deeply rooted in longstanding good law. And we've, we're in a particular moment, as Ms. Foote mentioned, where there's a wave of corrupt interference by the Trump administration with the fair administration of the law. And it's of paramount importance to give California the tools it needs. I'll heed Mr. Enson's admonition to kind of name some cases here. I think that's a good and fair request. I'll name the Microsoft Activision case. That was a case that the Federal Trade Commission lost in court back in 2024. And it lost that case because it misinterpreted the language of federal antitrust law to mean substantially lessen competition, that higher standard that I believe Commissioner Carrillo was referencing. That is not the same as the text of the law, which is maybe substantially to lessen competition. It's a slight distinction, but an important one. And that substantially standard is not consistent with Congress's intent. It is not consistent with Brown Shoe or Philadelphia National Bank, both of which cases were cited today by the California Attorney General in federal court to block the broadcast merger of Nexstar and Tegna. In the wake of the Microsoft Activision merger, what happened? Well, they closed a whole bunch of gaming studios. They laid off thousands of employees, things that they said that they were not going to do. And it's all because they got that standard wrong. I think we have an imperative to correct cases like that. I'll name another case, the merger of Kroger and Albertsons, the grocery super chains. Now, that case was blocked in 2024. But before it was blocked in federal court, it was actually blocked by the states, not California, because we don't have an explicit anti-merger law, but by Colorado and Washington in their respective state courts. So California was behind the curve in protecting its own residents in state court. As to the appreciable risk standard, this commission is in search of a standard that is lower than that inaccurate, substantially lessen competition standard. We are searching for something other than a reasonableness standard. Mr. Syed, I believe, conceded that a 50% threshold is too high. We are looking to affirm Congress's original intent, find language that is rooted in the law. I would submit to this commission that appreciable risk is that language, that we have done that extensive search, that staff has done that scholars long before this commission existed have done that search. It's been the subject of discourse for years, and I'm not aware of a better term to express this principle that the threshold should be lower than 50%. You know, it is an elegant phrase that has provenance in cases like Brown Shoe. Mr. Land, I know, is familiar with something called the incipiency standard because he wrote the most influential article on the topic. And now that incipiency standard is rooted that's a term that comes from Brown Shoe. It's a case from the 1960s. And instructs the court to block mergers before a crisis of concentration occurs, to get mergers at that tendency to become a monopoly early on. And I believe that the appreciable risk standard is that incipiency standard. It is good law, and those words have dictionary definitions that inform the courts to prevent mergers before anti-competitive concentration occurs. I'll conclude my comments there, but want to thank this commission again for its tireless work on this. I do believe options 2, 3, and 4 got it right. I think they're compromised positions. We did ask for more. A lot got left on the cutting room floor, and that's fine because I think what's before you is a remarkable improvement to what we've got today. Thank you very much.
Thank you. Any questions or comments? Seeing none. Next presenter.
Peter Leroy Munoz.
And after that, we have none. Okay.
Good afternoon, Commissioners. I'm Peter Leroy Munoz, representing the Bay Area Council, a policy association representing more than 400 companies in the Bay Area economy. The Council is deeply concerned that the draft language under consideration creates a California-only barrier to the natural life cycle of our state's innovation economy. By lowering the evidentiary threshold from likely harm to a reasonable probability of a trend towards monopoly, the Commission is effectively closing the exit door for California startups. For many founders in Silicon Valley, being acquired is the primary path to scaling their technology and the overwhelming motivation to begin with a startup in the first place. If we chill the M&A market, we chill the venture capital that fuels the next generation of California jobs. Furthermore, we urge the Commission to reconsider the move away from federal alignment. Adopting a state-specific M&A standard that diverges from the Clayton Act creates a fragmented legal landscape. The proposed market share presumption is also challenging in the sense that it presents a blunt 20th century instrument being applied to 21st century markets like artificial intelligence and quantum technologies, where market leadership shifts overnight. Forcing companies to navigate conflicting standards between the DOJ, FTC, and California state courts, among others, doesn't increase competition. It increases litigation costs and administrative friction, making California a less attractive headquarters for global firms. Finally, prohibiting courts from considering the broader consumer benefits of a merger across different markets ignores the reality of the modern digital economy. If a merger results in lower prices or better integrated services for California customers, our courts should be allowed to count that as a win. Under the draft under consideration, those benefits are ignored solely to protect less efficient competitors. The Bay Area Council believes in strong competition, but competition policy must be grounded in the consumer welfare standard and national consistency. We urge the Commission to refine this language to ensure California remains a global leader in innovation rather than an outlier in regulation. Thank you.
Thank you. Any questions or comments for this presenter? Seeing none, hearing none. And that was the last presenter? Okay. Okay, be brief.
Oh, very brief, yeah. Ben O'Brien again here with California Life Sciences. I just wanted to add a little data to the context. I know it was discussed around drug approval rates in our industry. So I just wanted to cite some data from the National Library of Medicine. So this study where they were looking at FDA approval drugs rates over the past century, they found that the first decade had an average of 25 drugs approved per year. Then from 2011 to 2017, a rate of 34 per year. And then since 2018 to 2024, it's been about 50 per year. So I just wanted to add that data to kind of what was being brought up. I'd appreciate seeing the data that the professor was mentioning, kind of showing that consolidation actually translating to lower rates. But the data that we see from the FDA and from the National Library of Medicine kind of shows that trend increasing over time.
Okay, thank you. Okay, members, we don't have a quorum today, so we're not.
Mr. Chair, point of order.
Yes.
I took a look at our handbook and I sent you a screenshot of the relevant provision. I think once a quorum is established, we keep it.
Okay, but if we were to vote on something, we don't have 5 votes.
That's true. I think that doesn't matter. I'm not suggesting we do take a vote, but we still have a quorum.
Yeah, so
once a quorum is
established,
Okay.
would be a majority of the commissioners present. But I understand if that's, you're not there because we're down a few commissioners.
Right.
Yeah. Again, I'm not suggesting we take a vote on anything.
Yeah.
Just
Yeah, but
point of
certainly.
order. We do have a quorum.
Giving
Yeah.
direction to, yes, okay. Yeah, that fair point. Yes.
So, and we would appreciate direction.
Yes.
From the commission.
Oh, I have some.
Oh, great.
I have some.
I'm just trying to make a checklist.
Go first then.
But I don't want to steal the floor. Commissioner B,
No.
Commissioner Simpson, if
No,
you have any
yeah.
thoughts, if you want to go first, I'm happy to wait.
No, go for it.
Okay. I think we want a standard. I would go back to the drawing board and I would give some significant deep thinking to reconciling the competing positions we've heard here today, some of which were exceptionally lucid and well thought out. I would give some thought to reconciling those and deciding on not just a standard, but the language used to express that standard so that there is a union of those two things. In other words, the language we use should specify what standard we are trying to articulate. I do not think that we should go in the direction of something that is purposely vague or even leave it open to interpretation. So whatever phrasing we pick, we live or die by it. And it should be very clear about what standard for the plaintiff's initial burden of proof we are recommending to the legislature, whether that be de minimis, which translates to like 1%, or beyond a reasonable doubt, which is clearly more than 50%, or more likely than not, which is 50% plus 1. Like whatever language we pick, I want to be specific about it. But before that, I think that the gestalt of the discussion we've heard here today is, I don't think we have consensus on what that standard should be. So I think we got to get there first, then decide on the language that expresses that. And it should be a standard. I'm more convinced than ever that tying ourselves to a specific percentage here would be committing the same error that we dodged in single firm conduct. So, for example, one way to step on that grenade would be to incorporate and tie ourselves to the HHI analysis. I think that can be a factor in a trial court's evaluation of the evidence, but I would not include that as either the presumptive standard. I wouldn't even include the language in the statute. I think we could reference that in a list of other things that a trial court could consider when it's evaluating the evidence to match the evidentiary presentation of the plaintiff against whatever standard we articulate in the first part. But I wouldn't tie ourselves to the mast on that one. 2 more points. I do like the staff's recommendation that we tie this language to the same thing in the single firm conduct, that federal law is persuasive but not binding on California courts. I think we definitely have consensus on that being a good idea. And then the last thing, and thank you, Commissioner B, for pointing this out. I missed this. Footnote 21 on page 4. I disagree with the staff's recommendation to strike that sentence in subdivision D. Quite the opposite. I think we need that. And that's the vehicle for getting in HHI and any other factors that we want the court to be able to consider. So I think we go the other direction. I think we keep D and we use that to signal to not even signal, to tell trial courts, here are the factors that you can consider in evaluating the plaintiff's initial evidentiary presentation against whatever standard we articulated above in subdivision C. Those are my thoughts. Happy to discuss.
Yeah, Sarah?
Thank you, Commissioner. A few follow-ups. When you mentioned the clear standard, you referenced terms associated with, I guess, criminal or other civil law, but you want something that is tied to existing case law specifically, something with a track record, or can it just be?
So this is the part where I think it requires some deep thinking before we even get to what language are we going to use to express the thought that we have after we do that deep thinking. I think we're still at that initial starting point, as reflected in the fact that we have an array of options on the table, and each of those options articulates a very different burden of proof for the plaintiff. So I would ask you to go back to the drawing board and come up with a proposal for what that standard should be, what that burden of proof should be. And I would hesitate to put it in percentage terms, but it's sort of the easiest way to talk about it right now. Like I said, it's somewhere between 1% and 51%. I don't think it's 1%, and 51% is probably too high. So it's somewhere between those. There's a lot of discussion has been in terms of viewing this from, like the Posnerian way of looking at this or framing it as from the perspective, it's a presumption. These mergers are presumed to be bad. And that really, the action is in shifting the burden of proof quickly to the defendant to make the required showing that, no, this is actually fine and everybody will make a lot more money and, it'll be the best thing since sliced bread. So if we buy that formula, that theoretical formulation of this area of the law, then we should be moving quickly past the plaintiff's presentation. It should be a fairly low bar. The requirements on the plaintiff should not be onerous. They should be light, not de minimis, not almost nothing, but probably not as high as 50% plus 1, which is what you would need to win at trial. So it's insane to say your initial burden to shift the burden of production onto the defense is the same as what you would need to ultimately win this case at trial. That makes no sense. So it has to be below that. And again, I don't want to put a percentage on it, but I think what we're looking for is language that expresses an idea that this is a fairly low bar and that the point of this test is to fairly quickly get to the defendant's showing on why this is actually okay.
Do you want us to include appreciable risk in there?
Again, I think that's the second step. I think the phrasing you use is less important than deciding on what concept you're trying to communicate in the first place. So if you want to approach it that way, first tell me what appreciable risk actually translates to. And then we can decide whether that's the right standard.
You also mentioned with referencing that federal law is persuasive, but not necessarily controlling. Did you want that independently, or is the commission interested in tying to the full purpose statement that's used for single firm?
I thought the suggestion about tying to the one that we've already spelled out in single firm that makes sense to me. I don't think there's a reason to repeat it. Well, Rick, you tell me. The only reason to repeat it is if we're worried that single firm conduct is not going to get enacted, and if it does, then we'd be referring to a nullity.
Yeah, a non-existent.
Yeah.
We could do a double joining thing.
Well,
right.
We don't need to get into that deep into ledge speak, but I think we can draft it both ways and we'll, so it's ready depending on what happens with single firm conduct.
Yeah.
Honestly, I would probably just add it as a section or a point section after this or something.
Just cut and paste it from single firm conduct.
Yeah, so it would show up, if both were enacted, it would show up 2 places in the BNP code.
That's fine.
Isn't that statement specific to single firm conduct? I mean, doesn't it have language in there about single firm conduct?
Right now, we say that the section applies to the specific sections, so we would just kind of add the section number for mergers in there.
But we will go back through and confirm whether there's some.
Yeah.
Or you can just copy paste that into subdivision F here.
Yeah, I don't think I would put I wouldn't take the single firm version and put the mergers and acquisitions reference to it. I would have a separate
one.
section.
Okay.
Because if there's 2 bills going forward and
Right.
single firm fails and
Right.
mergers passes, there's no.
Right, there's
it doesn't
nothing there.
exist. Yeah, so I'd have a separate
And
section.
we can monitor
Yeah.
it throughout the process, if things change.
Yeah, I tend to agree with Mr. Carrillo. And I'm still on the appreciable risk versus may versus more likely than not versus whatever as the probability of anti-competitive effects. I tend to agree that we should try to be explicit about what the likelihood of this merger causing bad effects is, but then there's also how bad it's going to be affecting competition. That's where the de minimis sign comes in. Is it going to be? Are we going to substantially lessen competition? Are we going to lessen competition more than just a de minimis teeny weeny bit? Are we going to whatever? Because you've got 2 descriptors in there. It's how likely is this merger going to affect competition? And if it affects competition, how bad is that effect going to be? We've got both in there. And so I want to make sure we're being more explicit about where they are. I mean, if there's a appreciable risk, that's the probability. Appreciable risk of a small effect, of a big effect on competition. I mean, we need to distinguish that, I think, in how or if there's a high probability of even a small anti-competitive effect, is that something we want to be concerned about as well? So those 2 things, it seems to me, are something we need to think through and try to make some.
Rick, can I make one point on that last thing you were saying? I think it was Mr. Said who was pointing out that determining the market answers a lot of questions, and then it's up to the factual determinations. So for example, looking at option 2, page 4, subdivision C, first line, a merger that may, which is the probability or likelihood you're talking about, that's the first thing, produce a firm controlling an undue percentage. I think that gets to the second part of the prima facie showing that you're focused on. How bad is it?
Yeah.
So how likely is the effect, and then how bad is the effect? I think that undue percentage, so at first you might think that undue percentage creates the same problem that I'm identifying on the first element of plaintiff's prima facie case. Well, undue, what does that mean? That's just as vague as may or appreciable or,
substantial.
Yeah, God only knows. But on the effect element, I think there I would be a little more willing to let that be fact determined by the context of whatever market. So for example, I think it was Mr. Said was saying, there's a big difference between a market that once you go through the work of defining the market, there's a big difference between a market where there's 5 players and 3. So if you go from 5 players to 2 to 4, that's a very different scenario than going from 3 players down to 2. So One of them is much more obviously an undue percentage of share of the market than the other one.
So what I'm hearing is you're more comfortable with that existing language as quoted from Philadelphia Bank.
I think on both of these, I suggest that we want a standard. I think that the standard can be a little more fact dependent on the percentage share. So I'm more comfortable with the current phrasing undue percentage share because I think that's largely going to be determined by the market characteristics. I'm more comfortable with that, much less comfortable with something like may. Trying to think of this from the perspective of, okay, I'm a trial judge and plaintiff walks in with a bag full of evidence. It may produce an effect. It may not. Who knows? How am I supposed to sort that out?
But those are two different things. Undue
Yeah.
is how bad it is.
Yeah. So I'm saying I'm more willing.
May is whether or not something's going to happen in the first place. May is the probability.
Yeah. And I want more specificity on may, and I'm more comfortable with less specificity on undue.
Okay, on the magnitude of the harm.
Yeah, because I think it's easier to make a factual showing on the badness of the potential harm, and it's harder to make a factual showing on the likelihood of it.
Okay.
And if you've ever played poker,
yes,
you know how hard it is to figure out probabilities and how often they prove out to be wrong.
And I tend to, I think, agree also with Commissioner Carrillo's concern about having the HHI stuff as statute and that obligates courts to use it. I think having it as part of this, whatever the subdivision as we had, subdivision D of persuasive authority and complements, complements the law. Kind of like, I mean, sort of the kind of the little more explicit version of the what do we call it, the purpose statement. I mean, that kind of a reference to it, rather than having the 1800 or 100 numbers in law, that's what triggers the presumption.
And I agree. I think I agree with all of that. I mean, in essence, it's shifting all the work to you to figure out what the proper language is.
I think we have a lot of experts that like to help as well.
It's a burden shifting, yes.
Right. Yes.
I'll be calling all of you.
But I think that's right. I mean, it seems pretty difficult because we've been sitting here for several hours trying to think about what that language should be, and none of us has quite come up with it yet. So if you can, bravo.
Options.
I think what I'm most looking for is an expression of what the philosophy is here, and fairly clear language articulating that. So if the philosophy is we want plaintiff's prima facie case to be very easy to make, and we're going to strongly signal that clearly to courts by saying plaintiff only needs to make a de minimis case. A de minimis showing. That's their evidentiary burden. Okay, that's pretty clear. It's both clear in the philosophy and it's clear in its articulation. There's a union between the two. Or if the philosophy is we want lots of mergers, and so the plaintiff's burden should be really high. We want clear and convincing evidence. Okay, that's a philosophy and it's well articulated. So whatever, that's why I would do it the other way around. I would decide on what's the philosophy, like how easy do we want to make it for plaintiffs to state the initial prima facie case and shift the burden to the defense? How easy do you want to make that? and then come up with language that expresses that philosophy. That's
Right, or give us, if you want to make it hard, here's the kind of language you use. If you want to make it, easy or easier, here's the kind of language you would use.
So you're looking again for something between 0 and 50%.
Yeah, and again, only for purposes of discussion here, I definitely do not want to see a memo that says plaintiff needs to make a 23.5% showing. Like that's okay, that's insane. But for purposes of discussion, like 1% is a philosophy, expresses behind it. There's a philosophy that these are very easy showings for plaintiffs to make. If it's something that indicates 2/3, 66%, clear and convincing evidence, 90% beyond a reasonable doubt, then that articulates a philosophy that it should be very difficult for plaintiffs to make these showings. We want lots of mergers. And I'm sure that the expert teams are going to have lots to say about the philosophy behind this. But whatever language you come back with, it's going to tell me what the philosophy is, or at least it should.
Yeah, or give us options. If you want something a low standard, here's what language should look like. If you want a preponderance of the evidence, here's what it should look like. If it should be a high standard, here's what it should look like.
Given the tenor of the discussion so far, should I focus the work on making it easier to bring cases than currently perceived under federal law?
I don't know what the perceived standard is under federal law now.
I guess in my view, if they're applying what we believe to be the wrong standard of more certain versus reasonably, I forget the language.
It's lots of words.
Yeah, but the lower standard, I would focus on the lower standard as where we're headed in terms of the burden.
That sounds like the disconnect. It's at least what I'm gathering from the experts is that to the degree that there is the consensus is that federal law diverges from California law in that it sets a higher burden of proof for the plaintiffs than California law or arguably the Clayton Act should.
And I'd want to hear what do we think that standard is that the feds are using? Are they using a more likely than not or something more like clear and convincing? I mean, what kind of standard do we think the feds are using in order to shift that burden to the defendant? So that's what's not clear to me.
Well, and I think federal law certainly draws a distinction between the vast number of the majority of mergers which don't raise concerns and those which take place in a highly concentrated market where there's very few players, where you have a higher standard or you shift the burden of proof. So I do think we have to think about having at least two different standards. And that's what federal law does.
Right, but is that the public policy that we think makes most sense? Should we have a low standard in?
Well, low standard. I mean, we're also talking about an incipient standard, so we can't.
I don't know what's that mean. Incipient standard.
Incipient. We're asking the parties to really prognosticate about what the effects of the merger might be. So they're not bringing forth evidence as to what the effect of the merger is because it hasn't taken place.
Right.
So they're just making forecasts of what the dangers might be. We don't have California law that's similar to that. I mean, in antitrust, you typically have to show the anti-competitive effects of the conduct, the single firm conduct that we've been dealing with. Mergers is a different ballgame.
Right. I get
You're
that.
just asking, reach into your crystal ball, use your economic modeling, use whatever knowledge we have from economics and experience to tell us which of these mergers is going to be most problematic.
Yeah.
The rest of the mergers, we're not going to, get our knickers and whatever, our foot in our knickers or whatever.
Right.
And so we want to focus on the ones that are most problematic.
And how do we know they're most problem? How do we?
Well,
what makes you think
that's
that?
why the merger guidelines say, let's use HHIs. Let's look at Philadelphia National. Let's look at the concentrated industries. That's where we know more mergers are most inherently anti-competitive. That's where we're gonna focus our energies, and we're gonna try and do something to make those cases easier and more efficient to litigate. So I think we have to have a tiered response, and I think that's what we try to do here, but we maybe haven't articulated it.
Okay. Oh. Okay. Professor Land?
Yeah, thank you. Thank you very much. I appreciate the being called on at this very late stage. One thing that we have perhaps not given as much emphasis to as we should have is the central role of judges in this process. A really conservative judge will look at a particular situation and not see any problem. A more moderate judge is just much more likely to look at the same facts and see a problem. I can remember the very first merger case I worked on at the Federal Trade Commission. I looked at the facts and said, that's a real problem. We should challenge it. A very conservative economist that I was working with looked at the same facts and said he didn't see a problem. I think many of us believe in the testimony of people like Professor Quokka that there's been too many mergers allowed, like the Live Nation Ticketmaster merger, and we have to make sure that sort of thing doesn't happen again. If they're in front of an ultra-conservative judge, they're going to allow those mergers. They'll look at the same facts that more moderate judges would look at, and they'll come to a different conclusion. So let me give a saying from the antitrust world, which is an exaggeration, but I'll say it anyway. Whichever side has the burden of proof is probably going to lose. That's why we're fighting over the Philadelphia National Bank presumption. If you have a strong Philadelphia National Bank presumption, no matter how we word it, a lot more mergers are going to be prevented. Without a Philadelphia National Bank presumption, without a strong Philadelphia National Bank presumption, especially with that word, the defendants have to clearly overcome it. The situation is going to be the exact opposite. So that's why we're all worrying about not just the words of the statute, but the presumption. How strong is the presumption? And then we can get into the details. If we all agree, there should be a strong presumption against mergers once the market is very concentrated with a significant increase in concentration. Thank you.
Okay. That's helpful. Thank you. Good context. All right. Any final comments, suggestions from commission members? In that case, is there any objection to adjourning?
I move to adjourn.
All right. All right. All in favor, raise your hand. I raise my hand. We are adjourned.
Thank you.